All right, so let's start with Ms. Quick. You're the one that's up top. Who do you have, Ms. Quick?
Good morning. I have Aaron Harris and Jalen Morgan.
Are they both not in custody?
Both not in custody.
Yes, this is.
Just 1 second. I'm going to admit Mr. Harris. Thank you. This is the people of the state of Michigan versus Aaron Harris. Case number 20 F61689. Mr. Harris is charged in count 1 with weapons carrying concealed, and in counts 2 and 3 with police officer assaulting, resisting, obstructing. May I have your appearances, please? Thank you.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Aaron Harris. Mr. Harris is out of custody. I'd ask to waive his appearance this morning.
All right, thank you. Mr. Harris is admitted into the Zoom room. It looks like his audio is working. He has not started his camera. Mr. Harris, can you hear us? The court is going to waive Mr. Harris' presence for today's hearing. This is the date and time set for a probable cause conference. Ms. Quick, is this the first probable cause conference?
It is not. It is the second probable cause conference. However, we are still missing digital discovery.
All right. Counsel? Speak with your microphone too, please. No, I don't think that works. You gotta go to that microphone.
According to the evidence.com record, the discovery was sent, looks like 3 different times, so I think that maybe council just needs to check the inbox for that.
Are you able to hear him, Ms. Quick?
I can barely hear him. It sounds like he's saying that that it was sent. I would ask if he would just send it one more time. I can give him my email address, or he can send it directly.
All right, can you have that forwarded to her once more, Ms. Quick? If you don't have it, you need to let the court know immediately so that we can address that issue. He's indicated that he sent it on more than one occasion. She has the paper, but not the digital discovery. Is there a digital discovery, Counsel?
Yeah.
I believe there is still and paper, but I believe
Okay, our motion today, good morning, is set for 10 o'clock.
earlier in December. But I can send it again, it's not a problem. Just
All right, she's gonna send it again, Ms. Quick.
I appreciate that. Thank you.
We'll schedule this matter for an in-person exam to occur June 21st at 10 a.m.
Thank you.
All right, is there anything further as it relates to this matter?
Nothing from defense, Your Honor.
All right, thank you. This is the people of the state of Michigan versus Jalen Morgan. Case number 20 F61699. Mr. Morgan is charged in count 1 with weapons carrying concealed. Your appearances, please.
Good morning, Stephen Carr, on behalf of the people.
Good morning.
Good morning. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Jalen Morgan. Mr. Morgan is out of custody. I do not believe he is on Zoom, and so I would ask to waive his appearance.
All right, thank you. The court is going to waive Mr. Morgan's presence for today's hearing. He's not in the waiting room. Today's the date and time set for a probable cause conference. Ms. Quick, is this the first PCC?
It is the second PCC, but again, I did not receive digital discovery. I have no record of receiving it.
Mr. Carr, do you have any digital discovery?
Yeah, again, I have a record that video and paper were sent on December 9th. I can resend them, but just look out for it.
So If you can check the records for December 9th, that's where when he's indicated it's been sent. He will, however, resend it, and we'll schedule this matter for an in-person exam. So the next date is going to be June 21st at 10:30 a.m. That's the in-person exam date, Ms. Quick.
Very good. Thank you so much.
All right, you're welcome. Mr. Cripps, good morning.
Good morning, Judge. How are you?
Good, thank you. What do you have?
For two probable cause cases. One is Taja, T-A-H-J-A, last name Dillon.
Ms. Dillon is in or out of custody?
Out, on bond.
All right.
And
the second
the
one
other
you have,
cases-
please.
I'm sorry, Judge.
Who's the second person you have?
Ronald Segars, S-E-G-A-R-S. He's in jail.
Okay. This is the people of the state of Michigan versus Taja, T-A-H-J-A, Dillon. Case number 20 F61686. Ms. Dillon is charging count 1 with license, documents, plates, forgery. May I have your appearances, please?
Good morning, Your Honor. Jacob Slusky on behalf of the people, P18677.
Good morning, Judge. David Cripps, P34972, appearing on behalf of Ms. Dillon. I would waive her appearance for the probable cause conference.
All right, thank you. Ms. Dillon is out on bond, so the court will waive her presence for today's probable cause conference. Mr. Cripps, this is the first PCC, correct?
Yes.
No.
I'm asking for another PCC date, Your Honor.
Actually, there was one in December, so
All right.
do you have discovery in this case?
Yes, I do.
Okay, so what the court is going to do is schedule this matter for an in-person exam to occur on June 21st at 11 a.m.
It's fine for me, Your Honor.
All right, if you're able to resolve this short of the exam date, please let the court know sooner rather than later.
Judge, what was that time again?
11 a.m.
Thank you.
You're welcome.
Okay, and Mr. Cripps, I do want to let you know that we can, if your client is interested in the plea, we can reduce it to unlawful use of a license plate, 257.256, if your client's interested.
Could you give me that site again?
257.256.
Thank you. I'll talk to her about it right away.
All right, thank you. This matter is concluded. Mr. Cripps, we're going to have to wait for the jail.
Yes, Judge, I'll check back later then.
Okay.
All right, I'm sorry. Actually, Mr. Cripps, I just received information that your client, Mr. Segars, is in the COVID ward. So it'll be 14 days before they'll be able to bring him before us. So we can call it a case. This is the people of the state of Michigan versus Ronald Segars. Case number 20 F62514. Mr. Segars is charged in counts 1 and 2 with assault with intent to murder. Counts 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation. Counts 5 and 6, assault with a dangerous weapon. Count 7, weapons, firearms, possession by felon. And counts 8, 9, 10, 11, 12, 13, and 14 with weapons, felony, firearm, second offense notice. He's placed on notice that he is a habitual offender 4th with a mandatory 25-year sentence. May I have your appearances, please?
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513. I'm standing in for the prosecutor of record, Mr. Larry King.
And good morning, Judge. David Cripps, P34972. I'm here for Mr. Segars.
All right, thank you. Ms. Johnson, I didn't hear who you were standing in for.
I'm sorry, Your Honor. Larry King.
All right, thank you. So Mr. Seegers is in the Wayne County Jail, and he is still on the COVID unit. He was on the COVID unit when we were last here on January 7th, and he remains there. We'll have to adjourn this matter again. We'll set it for February 4th at 8:30 a.m.
Thank you, Judge.
All right, thank you.
Your
great
Honor,
day,
I had
Your
a general. Your Honor, I had a general question before you move on to the next case, please.
I'm sorry?
I had a question. I had an in-person exam today. Is the court back open to the public?
Not only for in custody defendants.
Okay, all right. Thank you.
We will be back open, this court will be back open to the public, for non-custody defendants starting February 1st.
Okay, so okay, I'll just hold on for you to call my case then. Thank you.
You're welcome. Mr. Hortles, you're next. Good morning.
Morning, Judge. I have Robert Thompson. It's an in-custody case.
All right, can you stand by?
Of course.
Thank you. And Mr. McRipley, what do you have?
Morning, Judge. I have Mr. Graham.
Do you have Thompson?
Thompson?
Yeah.
No,
Okay.
but I was thinking, yeah. His name is Gilbert.
Who did you say, Mr. McRipley?
Derek Graham.
Mr. Graham in or out?
He's on bond.
Okay. I'll admit him in the proceeding. This is the people of the state of Michigan versus Derek Graham, case number 20 F61777. Mr. Graham is charged in count 1 with weapons carrying concealed. May I have your appearances, please?
Good morning, Stephen Carr on behalf of the people.
Thank you. Good morning.
Good morning. Good morning, Judge. G. Whitney McRipley on behalf of Mr. Graham.
All right, thank you, Mr. Graham. If you can please state your name for the record, sir.
My name Derek Graham.
Good morning, Mr. Graham.
How you doing?
This is the second of each. I'm sorry.
That's okay. Today's the date and time set for a probable cause conference. It looks like we have already been here on a PCC. Mr. McRipley, would you like to have this matter set for an in-person exam?
Yes, but still don't have discovery as well.
Mr. Carr.
Paper or
I can
digital.
resend the story again. I do have here that it was sent on December 8th, if you want to check your inbox. But I'll send it once more.
Yeah, just if you can stand again, I'd appreciate your kindness.
All right, so the court will schedule this matter for an in-person exam to occur on. Up to the I would say that.
Good morning.
9. Okay, June 21st at 11:30 a.m.
That's fine, yeah.
All right.
And Mr. Graham, I'll send you the police report as soon as I get it.
Okay, thank you.
Uh-huh.
All right, if there's nothing further, this matter is concluded.
Have a great day, Jan.
Thank you, too. Mr. Muad, good morning.
Morning, Your Honor. I have Alexander Koo,
Say the last name again.
K-U-E.
All right. Is Mr. Koo in or out of custody?
he is out of custody. He should be on. Alexander, can you
Oh, I see
identify
him.
yourself?
He's in the waiting room. I see
Okay.
him. This is the people of the state of Michigan versus Alexander Koo, case number 20 F62145. Mr. Koo is charged in count 1 with assault with a dangerous weapon, count 2 weapons, felony firearm. May I have your appearances, please?
Your Honor, for the defendant, Elias Muad, P41632.
Thank you.
For the people, Stephen Carr, sorry, Your Honor, I hadn't seen this one on my docket, so I hadn't pulled it on.
I'm sorry, I can't hear you.
Sorry, I hadn't seen this file on my docket, so I hadn't pulled it.
Okay. So today's the date and time set for a probable cause conference. Mr. Koo, can you please state your name for the record? Can you hear us, Mr. Koo? State your name. We don't hear you.
Can't hear you, Alex.
Alexander Koo.
All right, thank you. This is the second PCC in this matter. Mr. Muad, how would you like to proceed?
Judge, I think when I talk to my client, what we'd like to do is set it down for an in-person exam. Mr. Koo and I are going to continue to discuss on sending a possible gun board letter and seeing what their position on this. And I know that you're going out, I think, on some of these dates. So if we could do that, that'd be great.
All right. The court will schedule this for an in-person exam to occur on June 22nd at 9 a.m.
Okay. Okay. And then Alex, you and I are going to talk a little bit more. Okay. We'll go from there. Thank you, everybody. I do have the discovery too, Judge, so we're good on that.
All right, wonderful. Thank you.
Thank you.
Thank you.
Mr. Johnson, good morning.
Good morning, Judge.
Who do you have?
Mr. Taylor.
Mr. What'd you say?
Juwante Taylor.
Taylor. Okay. I'll admit Mr. Taylor. This is the people of the state of Michigan versus Juwante Taylor, case number 20 F61711. Mr. Taylor is charged in count 1 with weapons carrying concealed. May I have your appearances, please?
Good morning, Stephen Carr, on behalf of the people.
Good morning.
Good morning, Your Honor. May I please court Vassal Johnson P72130 on behalf of Mr. Taylor, who's present.
All right, thank you. So Mr. Taylor has been admitted to the hearing. It doesn't appear that he is at his device at this time. The court has been aware of his presence for today's hearing. This is the date and time set for the first PCC. Is that correct, Mr. Johnson?
It's actually second. I want to say the first one was December the 9th.
Okay. All right, so then is your client interested in having this matter set for an in-person exam?
Yes, I'd like to have it set for an exam in person. Just one issue. I did receive the evidence.com link, several videos. However, I can't play those videos. I downloaded them to a flash drive. If I would just ask if Mr. Carr could please resend, and that should take care of it.
Yeah, I can resend the videos. Is the issue that the format the videos were in didn't work?
Might be, because usually I don't have the problem after I download it to a flash drive.
I'll make sure that I forward and send them to you as MP4s.
Yes, that'll be great. Thank you.
All right.
Also, I did request the run sheets at our first PCC. I still haven't received those. I would just ask to obtain those run sheets or activity logs, which is the heading of the officers. If I can obtain those, that would be great.
All right, so he's looking for the run sheets or activity logs. Right. Davenport, you need to mute yourself. This matter will be scheduled for an in-person exam to occur on June 22nd at 9:30 a.m.
Thank you, Your Honor.
All right, thank you, Mr. Johnson.
Have a great day.
All right.
Thanks.
Mr. Magnuson, are you ready?
Yes, Judge, I just hung up my phone. Yes, I'm ready. I'm here on Brandon Brooks.
Brandon Brooks. Does this mean, I don't know.
I don't know who you look at the file. I haven't looked at the file.
It's no quick way.
Yeah.
Okay. I'll ask them. This is people of the state of Michigan versus Brandon Brooks. Case number 20 F62437. Mr. Brooks is charged in count 1 with weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3, weapons, felony, firearm. And he's placed on notice that he is a habitual offender for. Do you have your appearances for the record? And sir, Mr. Brooks, sit up, please.
And Mark Magnuson, Your Honor, on behalf of Mr. Brooks, who appears here on video via Zoom. Mr. Brooks, could you state your name for the record?
Brandon Alexander Brooks.
Good morning, Mr. Brooks.
Good morning.
Today is the date and time set for a probable cause conference. Mr. Magnuson, is this the first PCC in this matter?
Yes, it is. We would, I don't have the discovery on this matter, and I would request that I be provided the paper and, if any, digital discovery.
All right. Mr. Carr, do you have any digital discovery as it relates to this case?
I'm not sure right now, but I can check probably.
So will you please provide the paper and digital discovery that you may have in this case to Mr. Magnuson prior to our next date? Our next date is going to be a continued PCC to occur on February 18th at 8:30 a.m.
Thank you, Your Honor. Have a great day.
Thank you. You too. Mr. Brooks, we'll see you over Zoom February 18th at 8:30.
Thank you. Have a good day.
Thank you. Ms. Robinson, good morning.
Good morning, Judge. How are you?
Good. Who do you have?
Adam Smith.
Oh, yeah, that was from yesterday. Oh, is he in custody?
No, he's out. He should be in the waiting room.
Okay. This is the people of the state of Michigan versus Adam Smith, case number 20 F57448. Mr. Smith is charged in count 1 with assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon. He's placed on notice that he is a habitual offender second. Your appearances, please.
Good morning, Stephen Carr on behalf of the people.
Good morning.
Good morning, Judge. Brandy Robinson from the Neighborhood Defender Service, P66895, on behalf of Mr. Smith, who is participating by Zoom.
Okay. Mr. Smith, state your name for the record.
Adam Smith.
Thank you. Yeah. Today's the date and time set for a probable cause conference, or it says a hearing. What type of hearing is this, Ms. Robinson?
So, Judge, I was not aware that you were not doing that you were adjourning out of custody in-person exams, and so Mr. Smith and I were there yesterday at 1:30, ready for an exam, and it didn't happen. And so I've talked with him, and he would like to convert his matter from a live exam to a Zoom exam. So we need a date for that, please.
All right. Thank you. Mr. Smith, is that your desire?
Yes.
Okay. So I think we gave a date. Okay. So we gave Someone from your office stood in yesterday, it was Mr. Riggins, yesterday morning, and we gave not in custody exam date. The court will schedule this for a Zoom exam to occur on February 19th at 10 a.m.
Okay, that works for me. Mr. Smith, do you have any conflicts with February 19th?
No, ma'am.
Okay. At 10 a.m., Judge?
Yes, ma'am.
Thank you very much.
You're welcome.
You all have a good day.
You too. Mr. Potts.
Good morning, Judge.
Good morning. Who do you have?
Tyrone Johnson, he should be in the waiting room.
Okay, just one second.
Okay. You said it,
This is the people of the state of Michigan versus Tyrone Johnson. Case number 20 F59203. Mr. Johnson is charged in count 1 with assault with intent to do great bodily harm less than murder or by strangulation. And count 2 is a misdemeanor. May I have your appearances, please?
For the record, Your Honor, Coleman. Oh, sorry. Go ahead.
Sorry. Brittany Johnson on behalf of the people.
For the record, Your Honor, Coleman Potts, P78607 on behalf of Mr. Johnson, who appears by Zoom. Mr. Johnson, please state your name for the record, sir. You're on mute.
Sorry about that. Tyrone Antoine Johnson.
All right, good morning, Mr. Johnson.
Morning, Judge.
Today's a date and time set for an in-person examination. The court is not conducting in-person examinations for not in custody defendants at this time and will need to reschedule your exam. Let me ask Ms. Johnson, have you had any contact with the complaining witness?
Yes, Your Honor, I have.
All right, so you can set this for an in-person exam to occur on June 22nd at 10 a.m.
Thank you, Judge.
All right, you're welcome. You have everything to be correct?
Yes, thank you.
All right, this matter is concluded. Good morning, Mr. Simon.
Good morning, Judge. How are you?
Yeah.
Lawson, he's an bonder scheduled for 11 o'clock in-person exam. We'll need a new date.
All right, thank you. This is the people of the state of Michigan versus Khalil Lawson. Case number 20 F59114. Mr. Lawson is charged in count 1 with controlled substance possession less than 25 grams. Second or subsequent offense notice. Count 2 is a misdemeanor. He's placed on notice that he is a habitual offender. Third. May I have your appearances, please?
Good morning, Stephen Carr on behalf of the people.
Good morning.
Good morning, Your Honor. Jonathan Simon, P35596 on behalf of Mr. Lawson. He is on bond and I ask to waive his presence.
All right, thank you. The court will waive Mr. Lawson's presence for today's hearing. And the court is going to have to reschedule the in-person exam to June 22nd at 10:30 a.m.
June 22nd, 10:30 a.m. is good. Thank you, Judge.
You're welcome. If there's nothing further, this matter is concluded.
Thank you. Take care. Stay safe.
Okay. Mr. Davenport, good morning.
Morning, Judge. How you doing?
Good. Who do you have?
I have Eugene Driscoll.
This is the people of the state of Michigan versus Eugene Driscoll, case number 20-F61-695. Mr. Driscoll is charged in counts 1 and 2 with controlled substance, delivery, manufacture, less than 50 grams. He's placed on notice that he is a habitual offender. 4, your appearances, please.
Good morning, Stephen Howard, on behalf of the people.
Good morning.
Good morning, Your Honor. Curtis Davenport, P82678, on behalf of Mr. Eugene Driscoll, who I don't think is on Zoom. I'd like to waive his presence for the purpose.
All right, Mr. Driscoll is out on bond, correct, Mr. Davenport?
Yes, yes.
The court will waive his presence for today's hearing. Is this the first PCC in this matter?
Your Honor, this is actually the second.
Okay. Would you like to have this matter scheduled for an in-person exam?
I would, Your Honor. And then I'd like to make one note about discovery.
And you'd like to, I'm sorry, I didn't hear you.
I'd like to make a note about discovery as well.
Go ahead.
So I did receive a packet of discovery that was paper and it was video. However, the videos I received, I don't think are for the appropriate case. And so I would like to receive the correct videos before the exam.
All right. You didn't get the correct discovery,
Yeah.
Mr. Carr. Sure that he receives.
Yeah, I appreciate it. I'll go back in and look and contact the OIC about getting the right videos uploaded.
Thank you.
And the court will schedule this matter for an in-person exam to occur on June 22nd at 11 a.m.
That's fine, Judge. Thank you.
All right. Is there anything further?
Not from
Nothing
the-
really? All right. Thank you.
Thank you very much.
You're welcome. Ms. Gage Robinson, good morning.
Good morning, Your Honor. We have Van Stewart for an in-person exam.
Okay.
I logged in the other day, let Brother Counsel know that I still don't have all of the discovery. For the second case, they sent me the discovery for the first case twice. I've indicated that 2 separate times on the record. I still don't have the discovery for the second case, nor do I have the videos. I only have paper discovery, and I need the inclusive of the interrogation video.
Okay. What do you have, Mr. Carr?
Yeah, so my apologies in advance. There was a mix up with this case because of the 2 cases. As probably was saying, there was discovery, was the same discovery was done twice. So I talked with the officer in charge and in the process of getting the right discovery for the other case. Can you just verify for me which discovery did you receive?
I received the discovery from, I believe it's the December 22nd case. It's a Ford, a red Ford. Hold on 1 second, I can pull it up.
Appreciate it.
It's a red 2011 Ford Escape.
Yes.
December 22nd,
Yes.
according to the information.
Yes, that's what I just indicated. I'm just trying to find the case number.
I have a 6274201.
So I have the number on the information.
Okay, give it now.
That case number is 2020-728-785. That's the one that I do have. That's the one they sent twice.
Okay.
I don't even know the date and time of the second incident.
The second incident was actually 2 days earlier, December 20th. I just received, I'm sorry, that file was missing and we haven't been able to locate it. So I just received investigators report again, I'm gonna duplicate that file and then send you discovery in that other case.
I do need all of the videos as well, including the video of the interrogation. This young man is 17 years old.
Sure. In the case with the red Ford Escape ending in 728-785, my witness is in Chicago.
We're not, okay, so you're coming down?
We were supposed to come in. I logged in early because we were supposed to come in. It's no point if we can't hold the exams. We can't hold the second exam. I thought you wanted to hold both of them together.
So
I don't have.
I can hold what's ready, and if it's not ready, after your several requests to obtain, I mean, you were just on 2 days ago asking for the discovery, you make the motion and we would go from there. I
can get dressed and come on down, Your Honor, if that's what you want me to do. I have no problem with that. I would absolutely love to make the motion. I do know that they're going to reissue it, but I will absolutely come down and make the motion.
Okay, so I guess we're going to go into a breakout room. You, Ms. Gabe Robinson, and Mr. Carr. Just a second. And then this one. Right, so, Ms. Gabe Robinson, no. Oh, can you join?
I don't have good techniques at all to attend to that.
Yeah, this is good. Oh. Let's wait. All right, it wasn't gonna work because I couldn't get the Polycon to go to the breakout room with you, Ms. Robinson. And
Okay.
everyone.
I can message Mr. Carr or the court my cell phone number if he wants to call me. That's not a problem. But
We're not on the record in this case right now. Let me find out. Are you ready to proceed, Mr. Carr?
Sorry, am I ready to proceed on both cases or one case or?
Well, are you ready to proceed on either case?
As to the case involving the red Ford Escape where my victim is in Chicago, there are 2 counts of resisting arrest. I'm able to proceed in part on those, but I'm not able to proceed on carjacking and shooting.
All right, so tell me why, or did you speak with your witness that's in Chicago?
Yes.
And how long are they in Chicago?
She was in Chicago. She was visiting Detroit when she was carjacked.
Okay. Does she have plans to come here for this exam?
So I told she, she said she could get time off work at some point, but she needs a little bit of notice before she can do that. So I told her that she said she has Zoom capabilities. She works remotely, so if she were allowed to Zoom in, she could do that. Never, but if she's going to need to come in to testify from Chicago, she's going to need a couple weeks.
All right. All right, were you able to hear that, Ms. Gaten Robinson?
I'm sorry, Your Honor.
Were you able to hear what he indicated?
Yes, Your Honor.
As to the other case, Mr. Carr, you did not have the file on that case, and so therefore you're not ready to proceed on that case?
I was able to, I don't have the file. I was able to contact with the OIC, and he is going to try to bring the complaining witness in that case into court today. So I believe I could go forward on that one.
Except she doesn't have discovery.
I don't have discovery. I don't have the video.
I know that. I know that. I know that. All right. Can you bring Mr. Stewart up, please?
Yeah.
Okay, we're gonna bring Mr. Stewart up. We're gonna pass on this matter until he's up here.
Okay.
Mr. Portals, good morning.
Yes, Judge. I think we're still waiting on the jail, right?
Oh, thank you. I forgot.
Yep, all good.
Miss Joseph, good morning.
Good morning, Judge. How are you?
Good. Who do you have?
I have Nicholas Perry, and he's out of custody. So first PCC.
Thank you. This is the people of the state of Michigan versus Nicholas Perry. Case number 20-F62445. Mr. Perry is charged in count 1 with weapons carrying concealed. May I have your appearances, please?
Good morning, Stephen Carr, on behalf of people.
Good morning.
Morning, Judge. Christina Joseph, P79668, on behalf of Mr. Nicholas Perry, who is out of custody and who I've been in direct contact with. So we would ask the court to waive his presence for the purpose of this hearing.
All right, thank you. The court will waive Mr. Perry's presence for today's hearing. Ms. Joseph, is this the first PCC in this matter?
Yes, Judge, this is the first PCC in this matter, and I do wish to submit a diversion request. So we would be asking for this matter to be set for one more PCC.
Thank you. The court will adjourn the probable cause conference in this matter to February 18th at 8:30 a.m. Does that allow you enough time to submit that information?
Judge, I believe that it should.
Is there anything further?
Nothing from the defense. Nothing from the defense, Judge.
Thank you.
I'll provide you with
Thank you.
discovery.
You have discovery, right, Ms. Joseph?
Yes, I do, Judge.
Great, thank you. Good morning, Mr. Godwin.
Good morning.
Who do you have?
I have Mr. Evans, Carr and Evans. He's in the waiting room.
I don't see Mr. Evans in the waiting room under his name, you know?
No, I don't know.
All right, did you need him or can you waive his presence?
I can waive his presence.
This is the people of the state of Michigan versus Karan Evans, case number 20-F62435. Mr. Evans is charged in count 1 with weapons carrying concealed. May I have your appearances, please?
Good morning, Stephen Carr, on behalf of people.
Good morning.
Sean Godwin, P74500 for Karan Evans, who is not going to be joining us by Zoom today. But I am in contact with him, and I'd ask that you waive his presence.
All right, thank you. Mr. Evans is out on bond. The court will waive his presence. This is the first PCC in this matter. I'm going to give you a new PCC date of February 18th at 8:30 a.m. Mr. Godwin, do you have discovery?
I have police reports. I do not have the body cameras and squad car.
Mr. Carr, do you have any digital evidence?
I'll reach out to the officer in charge and see if I can get that video if it exists.
All right, so he'll provide that to you, Mr. Godwin. Is there anything further?
Can you give me the name of the APA? I can't make it out.
Stephen Carr, C-A-R-R.
Oh, okay, great. Thank you.
All right, thank you.
All right.
There's nothing further. This matter is concluded. Mr. Burton Harris,
Good morning, Your Honor.
good morning. Who do you have?
I have a gentleman, two matters. First is a William Carter set for a exam today, and he's in the waiting room under Samsung Galaxy 18.
I got a Galaxy A01.
If that's the only Galaxy, then that's him.
Who's your second client?
Willie Gilbert, and he's not going to be appearing by Zoom. I was going to request a waiver of his presence.
Thank you.
That's also set for a preliminary exam today.
So we'll start with Willie Gilbert. This is the people of the state of Michigan versus Willie Gilbert, case number 20 F58364. Mr. Gilbert is charged in count 1 with assault with a dangerous weapon. Count 2 is a misdemeanor. Your appearances, please.
Morning, Your Honor. Brittany Johnson on behalf of the people.
Good morning, Your Honor. Robert Burton Harris, P81843 with NDS on behalf of Mr. Willie Gilbert, who is not present, asking Your Honor's permission to waive his presence today.
All right, thank you. Court is going to waive Mr. Gilbert's presence for today's hearing. This matter was scheduled for an in-person exam, and we are not proceeding to the in-person exam today. Ms. Johnson, have you had contact with the complaining witness?
Yes, Your Honor, I have.
Mr. Burton Harris, you'd like a new in-person exam date, is that correct?
Well, for Mr. Gilbert, he's an elderly gentleman. We spoke last night, and he actually is really worried about coming down. So if Your Honor is going to set the exam, I would say within the next 60 days, I will request an exam via Zoom.
So I wasn't going to schedule it until June.
Okay, that should be fine then.
Okay. So I will schedule this for an in-person exam to occur June 22nd. We'll set it at 10:30.
Give me 1 second, Your Honor. I just want to make sure that date is clear. You said June 22nd?
Yes.
At what time?
10:30 a.m.
10:30 a.m. That's fine, Your Honor.
All right. Anything further?
Not on this matter. Thank you.
Okay. Mr. Carter is not with his device, if that is him, and has not.
Well, I can proceed and waive his presence and just update him as soon as this hearing is over.
Thank you. This is the people of the state of Michigan versus William Carter, case number 20 F58720. Mr. Carter is charged in count 1 with police officer assaulting, resisting, obstructing. May I have your appearances, please?
Stephen Carr, the other people.
Thank you.
Robert Burton Harris, P81843 with Neighborhood Defender Services of Detroit on behalf of Mr. William Carter, who is not present via Zoom, asking Your Honor's permission to waive his presence today.
All right, thank you. The court will waive Mr. Carter's presence.
This matter is set for an in-person exam, Your Honor, asking for an adjournment.
Okay, so the court not conducting in-person exams for non-custody defendants at this time, and will schedule this for a new exam date to occur on June 22nd at 11 a.m.
Thank you very much.
You're welcome.
All right, have a good day.
Mr. Zaranek, good morning.
Morning, Judge. How are you today?
Are we waiting on the jail for you?
No, Mr. Lyons, I believe, is out. I haven't been able to find him anywhere where he's locked up. This is the third PCC.
All right, thank you. This is the people of the state of Michigan versus Derek Lyons. Case number 20 F61249. Mr. Lyons is charged in count 1 with weapons carrying concealed, count 2 weapons, firearms, possession by felon, count 3 weapons, felony firearm. He's placed on notice that he is a habitual offender third. May I have your appearances, please?
Good morning, Stephen Carr on behalf of the people.
Good morning.
Bob Zaranek for Mr. Lyons, Your Honor.
Thank you.
I've had no contact with Mr. Lyons, Judge. I know you told me back in December that I needed to have some contact with him, and you gave me this other opportunity to reschedule a PCC. I've written letters, left voicemails, left text messages. I've had no contact with him. I've checked whatever lockups I can. I haven't found him to be locked up anywhere. So I'm stuck.
Thank you. The court, Mr. Lyons has failed to appear and to be in contact, maintain contact with his lawyer, and therefore the court is going to issue a warrant to set bond at $5,000 cash insurance. If you're able to locate him, if he contacts you, just call my court and we'll get him in, get him arraigned on warrant.
Thank you very much, Your Honor.
You're welcome.
Have a good day, everybody. Take care.
All right, you too. Ms. Manarino.
Good morning.
Good morning. What do you have?
I was scheduled for a live in-person exam on a bonder this morning, Crystal Reese.
All right. So Ms. Gaten Robinson, I'm going to do Ms. Manarino's, Mr. Brown's, and 2 more, and then we'll bring your client up. This is the people of the state of Michigan versus Crystal Reese, case number 20 F55068. Ms. Reese is charged in count 1 with assault with a dangerous weapon. Count 2 is a misdemeanor. Your appearances, please.
Good morning, Stephen Carr on behalf of the people.
Good morning.
And good morning, Maria Manarino, P39531 on behalf of Ms. Reese. For purposes of this proceeding, Judge, I'd ask the court to allow me to waive her presence.
All right, thank you. The court is going to waive Ms. Reese's presence as she is out on bond. This matter was scheduled for an in-person exam, and this court is not going to conduct that exam today. So I'll have to give you a new date, Ms. Manarino. How was June? Yes.
That's fine. I just wanted to inquire of the prosecution whether or not they've had any contact with the complainant. This is a case that dates back to 2019. The parties, I believe, are family members, and I don't know what the status is at this point and whether or not the prosecution is ever going to be prepared to proceed.
So yesterday I left a voicemail for the plain witness, but I have not had contact with her.
No contact. We can schedule this a lot sooner if you like, Ms. Manarino.
I think I would like.
All right, so why don't we schedule this for an in-person exam to occur Monday, February 1st?
That's a good date for us.
All right, so then we'll see you all Monday, February 1st for an in-person exam at 9 a.m.
Thank you. Thank you.
You're welcome. Mr. Brown,
Morning, Judge. How are you?
good, how are you?
Good, thank you.
You have Ms. Edwards?
I do. She's in the waiting room. She just called me.
Okay, I'll admit her. This is the people Tina Edwards, case number 20F60540. Ms. Edwards is charged in count 1 with home invasion first degree, count 2 assault with a dangerous weapon, count 3 is a misdemeanor. Also calling the people of the state of Michigan versus Tina Edwards, case number 20F60539. She's charged in count 1 with home invasion first degree, count 2 is a misdemeanor. And on both cases, she is placed on notice that she's a habitual offender second. May I have your appearances?
Good morning, Your Honor. Brittany Johnson on behalf of the people.
Good morning, Your Honor. May it please the court. My name is Mark Brown, P number 39562, appearing on behalf of Ms. Tina Edwards, who's present via Zoom. We have no objection continuing via Zoom.
So it looks like Ms. Edwards has not connected. She's not at a device, so she is unable to hear us at this time. The court is going to waive her presence for today's hearing. These matters were scheduled for in-person exams today. Ms. Johnson, have you had contact with the complaining witness?
Your Honor, I left a voicemail, but I have not heard back.
Okay. Mr. Brown, your client still wants to have this matter conducted in person?
No, actually, if we could do it sooner rather than later, because she's on a tether and I think it's interfering with her work. I know she had a job that she could have gotten and was unable to do so because she had a tether. So she'd like to have it resolved as soon as possible if we can.
All right, she is now present on the video. Ms. Edwards, if you can please unmute yourself and state your name for the record. You'll have to unmute yourself.
Okay.
All right.
Tina Marie Edwards.
Good morning, Ms. Edwards.
Good morning, ma'am.
All right, so the court is unable to conduct the exam in person today. Your lawyer has indicated that you'd like to have this matter conducted sooner rather than later. And I can give you a Zoom exam date, which would be much sooner than the dates that I'm scheduling for in-person exams. Are you interested in that?
Yes, I would be.
Okay. So why don't we schedule this for the Zoom exam to occur? Can we do it next Friday, the 29th?
Just one moment, Judge. No, I can't. Unless if we do it right at 8:30, but other than that, no.
Okay, we can do it right at 8:30.
Okay, good.
Okay.
Is that? I hope that's not Sanford laughing at me for not being here at 8:30.
No, we're gonna do a Zoom exam at 8:30 on January 29th.
Very well.
All right. Is there anything further?
No, thank you very much. You all have a good day and everybody stay safe.
Thank you.
Thank you. Thank you, sir. Thank you, Your Honor.
Yeah. Mr. Evans?
Good morning, Your Honor.
Good morning. Who you got?
Roderick Martin.
Mr. Martin, in or out?
He's out.
Do we need new counsel assigned for Mr. Martin?
We do.
Okay, stand by. We'll make that call. Ms. O'Meara? Ms. Farkas, what are you waiting for?
Judge, I have an in-person exam that was set at 9:30 for Antonio Wimberly. And I apologize, I was on the record earlier with Judge Knapp. I don't know if you tried calling my name or not.
Did not. I thought, no. Okay, thank you.
And he should be in the waiting room, Your Honor.
All right, then we'll do these two and then I'll bring out Mr.
Judge, can you hear me? It's annoying.
Barely, Tara.
Is that okay? Is that better?
Yes.
Yeah.
Madam Clerk?
I'll call your case in a moment.
Oh, I just have to jump off. That's all. So in case anybody's looking for the APA on Daryl Porter, I have to jump onto Judge King's Zoom.
Thank you. Okay, so you're. Yes, you do that, but we're not quite ready. We're not quite ready on your case yet.
Right.
All right, Mr. Porter, can you hear me now?
Good.
Okay, I'm gonna place you back in the waiting room. Your lawyer just appeared, and as soon as we're ready on your case, I'll let you in, okay?
Thank you.
This is the people of the state of Michigan versus Antonio Wimberly. Case number 20F61588. Mr. Wimberly is charged in count 1 with assault with a dangerous weapon. Count 2 is a misdemeanor, as well as count 3. Also calling the people of the state of Michigan versus Antonio Wimberly. Case number 20F61587. He's charged in that information And count 1 with assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, assault with a dangerous weapon. Count 3 is a misdemeanor. And on both cases, he's placed on notice that he is a habitual offender second. May I have your appearances, please?
Good morning, Your Honor. Brittany Johnson on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Mr. Wimberly, who's present via Zoom. Looks like Mr. Wimberly is indicating he's having an hearing.
I'm sending him a message to connect his audio. The court is going to waive Mr. Wimberly's presence for today's hearing. This matter was scheduled for an in-person preliminary examination. Ms. Johnson, have you had any contact with the complaining witness?
I have, and I expect the exam to be very
Okay, I can hear you now. I can hear you. I couldn't hear you just like a minute ago.
All right, thank you. Mr. Wimberly, state your name for the record, sir.
Antonio Wimberly?
Thank you. Ms. Johnson, you said you have spoken with the complaining witness and you anticipate that the testimony will be very quick?
Yes, Your Honor.
Okay, so why don't we schedule this for an in-person exam to occur next Friday at 9 a.m. No, wait, I can't. Wait, no, I'm sorry. Let's do it February 1st at 9 a.m.
That works, Your Honor.
Okay, so Mr. Wimberly, you're going to be in the building February 1st at 9 a.m.
Okay.
And make sure you're here promptly. Is there anything further?
No, Your Honor. Thank you.
All right, thank you.
Mr. Wimberly, you're all set. You can log off.
All right, so come back February. I got to show up in court February 1st now, all right?
I'll give you a call.
Okay, cool. Okay, thank you.
All right, we're ready for Mr. Stewart.
Mr. Stewart, step on out, please.
Ms. Robinson, you ready? This is the people of the state of Michigan versus Van Stewart. Case number 2062.
Hey, how you doing?
Hold on just a second, sorry.
I'm logging out now.
Case number 20F62791. Mr. Stewart is charged in count 1 with carjacking and in count 2 with robbery armed. He's charged in count 3 with weapons, felony firearm. Also calling the people of the state of Michigan versus Van Stewart. Case number 20F62742. Mr. Stewart is charged in count 1 with carjacking, in count 2 and 3, no, I'm sorry, in count 2 with police officer fleeing, 3rd degree, and in count 3 with police officer assaulting, resisting, obstructing. May I have your appearances, please?
Good morning, Stephen Howard, behalf of the people.
Thank you.
Good morning, Your Honor. Attorney Phyllis Gayton Robinson, P71733, on behalf of Mr. Van Stewart.
Thank you. Mr. Stewart, state your name, sir.
Good morning, Your Honor. I'm Van Stewart.
Good morning. Today's the date time set for in-person preliminary examination. And the court has been apprised that on one of the cases by Mr. Stewart, Ms. Gayton Robinson has not received discovery. Is that correct, Ms. Gayton Robinson?
That is, I have not received any discovery. And with regards to the second case, the discovery is incomplete.
So Ms. Gayton Robinson has requested discovery on one of the 2 cases on more than one occasion. And the court has just learned in an off-the-record discussion with the prosecution that that file is still in the process of being turned over to you, Mr. Carr?
That's correct. I received the report from the investigator just this morning, and he's going to also upload video soon. So it'll be at least a couple more days before I'll have complete discovery.
Okay. As it relates to the file that Ms. Gaten Robinson does have discovery on, Mr. Carr, your complaining witness does not live in the state of Michigan?
That's right. That's case 627-4201. The complaining witness is Sheree Dunnigan, and Ms. Dunnigan lives in Chicago. I spoke with her yesterday and informed her of the date. She said she wouldn't be available to come today because she's working in Chicago. She also informed me that if the presence was required, she could take time off work, but she would need at least a couple weeks' notice. She also told me she was available via Zoom if she was permitted to testify.
All right, thank you. So this is what the court is going to do. I am going to allow you 1 week to get the discovery over to Ms. Gaten Robinson on the case that she does not have discovery on, and an additional week to see if your complaining witness is able to arrive here from Chicago. Oh. How's it 27? Next Wednesday.
For in-person exam, Your Honor?
Yes, ma'am.
Your Honor, I guess my request, while I can possibly do that date, this is my request. I can't keep, they limit the number of jail visits that they allow us to have. Yesterday, I had an hour jail visit scheduled with Mr. Van. We only were together for half an hour because we planned to discuss both cases. I need the actual discovery in my hand before I can even really fairly make an appointment, because I'm blocking up appointment times for other attorneys and I'm not fully prepared. Can we have 2 weeks? Okay. I should have the stuff next week.
Okay, that's fine. I'll give you. Okay.
I am in the building on February 3rd, or in theory, I'm supposed to be in the building on February 3rd. So if we could do it, if you have any openings later that day, I would greatly appreciate it.
Just a second, let us look at this horrible schedule. Oh, thank you. Let's figure it out. Oh, it's not good. It's not. It's really bad. Yeah. have 11 matters scheduled. We can do it the 5th, Friday the 5th.
Friday the 5th. At what
Yeah.
time, Your Honor?
11.
Okay.
All right.
So just to be clear, Your Honor, I'm supposed to receive complete discovery by next week for both cases because the first case is missing the videos, including the interrogation. And then I'll be able to schedule the jail visit for the next week before exam on the Friday.
Yes, ma'am.
All right, I just want to make sure. Thank you.
All right, thank you.
Have a great day.
We have prosecutor, Mr. O'Donnell, he went to talk to his client downstairs
On what case?
on, I think it's Watkins.
Yes.
Mhm. Would you step in, I'll have someone come get you. The prosecutor's out there as well.
Ms. O'Meara, good morning.
Good morning, Your Honor.
What do you have?
I have Cedric Hill. We're just asking for an in-person exam. I don't know if he's in the waiting room. I could waive his presence if he's not. I hope if it's okay with court.
That's fine. And Mr. Vickers, you're here on Porter.
Yes, ma'am.
Mr. Kennedy, who are you here on? You're muted, sir. Do you hear me, Mr. Cannon?
Yes, I'm here. I'm right here. Like I said, I'm checking in for, P82992. I'm checking in on behalf of Reginald Hill. We go to waive his appearance for PCC today.
I'm not. Okay, thank you. I just wanted to know who you were here on. And Reginald Hill.
Hi, this is Mr. Bowman. Hey, how are you? It's Mohammed Hassan. How are you?
Can you mute yourself now, Mr. Cannon? Thank you. This is the people of the state of Michigan versus Cedric Hill, case number 20 F62139. Mr. Hill is charged in count 1 with assault with intent to do great bodily harm less than murder or by strangulation. Count 2, weapons, firearms, larceny. Count 3, weapons, firearms, possession by felon. Count 4, larceny in a building. Count 5, 6, 7, weapons, felony, firearms, second offense notice. Counts 8 and 9 are misdemeanors, and he's placed on notice that he is a habitual offender third. Your appearances, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people.
And good morning, Your Honor. Catherine O'Meara on behalf of Cedric Hill.
All right, thank you. Mr. Hill is out on bond, correct?
Yes, he is.
This is the date and time set for a probable cause conference. Are you requesting an in-person exam?
Yes, we are. Thank you.
All right, so the court will schedule this for an in-person exam to occur on June 23rd at 9 a.m.
Thank you, Your Honor.
You're welcome. Anything further, Ms. O'Meara?
Nothing
No?
further. Thank you.
Mr. Bickert on admitting Mr. Porter. This is the people of the state of Michigan, this is Daryl Porter. Case number 20-F61959. Mr. Porter's charge in count 1 was criminal sexual conduct, 3rd degree. Count 2, criminal sexual conduct, 3rd degree. And he's placed on notice that he is a habitual offender 4. Your appearances, please.
May it please court, Your Honor, Tyrone Baker appearing on behalf of Mr. Porter, who I do not see as present, Your Honor, via Zoom.
Oh, he's here. Mr. Porter, state your name, sir.
In court. Okay, got you.
Oh, I'm sorry. This is Ms. Hendeling's case. And she indicated she needed to go to another courtroom.
Okay.
So we're going to pass on this matter until she returns.
Okay.
Mr. Porter, place you back in the waiting room.
Understood. Thank you. Let me see.
And, okay, we're going to do Reginald Peel. This is the people of the state of Michigan versus Reginald Peel, case number 20-F62515. Mr. Peel is charged in count 1 with larceny in a building. Your appearances, please.
Monte Cannon, PA 2992, on behalf of Reginald Hill. We'd like to waive his appearance today.
All right, he's not in custody, correct, Mr. Cannon?
Yes.
Okay. For the people?
Good morning, Stephen Carr on behalf of the people.
All right, thank you. Today's the date and time set for a first probable cause conference in this matter. Because it's the first PCC, the court is going to adjourn and give you a new date, Mr. Cannon, of February 18th at 8:30 a.m. Do you have discovery, Mr. Cannon?
We have a paper discovery, but we are still looking for a video footage.
Mr. Carr, can you check to see if there is any video? And if there is, can you please provide it to defense counsel? Is there anything further, Mr. Cannon?
Just confirm, Your Honor, that is February 18th for a new PCC?
That's correct. Is that it?
Yep, that's it, Your Honor.
All right, thank you. You're all set. Okay, we can see who is here. Starting on your Are you ready? Madam Prosecutor? We're ready whenever the court's ready. Okay, we're ready. Oh.
Judge, apologies if I'm interrupting. Have we heard anything about the jail?
We have not.
Okay. I know Mr. Nelson has been here a long time. I'm not sure what else he's got going on today. At what point would the court want to call this case?
It's still early, so we can hold on at least until lunchtime. We just have some in-person matters that are going to be going down. So if
Okay.
you want to, or as soon as the jail calls in too, I'll stop the proceedings and go forward with that. We're not holding up the jail.
Understood. Yeah, I was just on docket A and Third Circuit. There are quite a few jails still connected there, so totally understandable.
All right.
And with Mr. Thompson's case, there is a co-defendant, Darnell Irby. I think Carla Maribel is his attorney, and I haven't seen her on this Zoom yet. So I guess we probably need to coordinate with her.
Yeah, I don't recall that co-defendant being present for our last PCC. I think these cases might be disjointed on the schedule.
All right, so if you want to contact Ms. Maribel, if the other defendant is on the docket today and let her know what's happening. Is her client in custody as well?
As far as I know, yes.
Okay, so you might want to check in with her and let her know that we're waiting on the jail, and we'll reach out to you once.
I will. Thank you.
All right. I'm ready for the watch.
Mr. Watkins, don't lock the door right here. Stand right for that chair. Right here.
Party's ready on Darius Watkins.
Just stand there for the cases called.
Mr. Park, you can sit in the back over there. That'd be perfect. Thank you. This is the people of the state of Michigan versus Darius Watkins, case number 20-F61745. Mr. Watkins is charged in count 1 with criminal sexual conduct first degree personal injury. Count 2, criminal sexual conduct first degree personal injury. Count 3, criminal sexual conduct first degree personal injury. And in counts 4 and 5 with criminal sexual conduct first degree personal injury. He's also charged in counts 6, 7, 8, 9, 10, and 11 with criminal sexual conduct first degree incest. He's placed on notice that he is a habitual offender for your appearance, please.
Good morning, Your Honor. Susan Dillon on behalf of the people. Good morning.
And good morning, Your Honor. James O'Donnell, P42585 from the Neighborhood Defender Services, representing Darius Watkins.
Thank you, Mr. Watkins. Can you please state your name to the record, sir? Good morning, sir. Today's the date and time set for an in-person preliminary hearing. Are the parties ready to proceed? People are ready, Judge.
Yes, Your Honor.
Okay. Any preliminary matters?
Your Honor, we will expect to call one witness today, Jessica Watkins, and I also have a certified copy of the medical records that I'll want to admit to the court, and I can do that either now or after.
All right. Whatever you like, and I'll need for everyone to speak into the microphone so that the court reporter is able, and I'm able to hear. There's a lot of class.
We have a microphone with the.
Oh, there is one there, yes, okay.
Do you mean this microphone, Judge, right here?
Yes.
Okay.
All right, Ms. Dillon, you can call your first witness.
Your Honor, the people would call Jessica Watkins.
Ms. Watkins, if you can provide the spelling of your name to the court report, please. And if you can turn towards me and raise your right hand, do you swear or affirm that the testimony you'll provide will be the truth? Yes. All right, you're gonna have a seat in that chair. There's a microphone to the right of you. You can grab it and place it in your lap. The red light should be on, and we're gonna need you to speak into the microphone loudly and clearly. Okay. All right, thank you. Ms. Dillon, you're ready.
Your Honor, thank you. Just as a preliminary matter before we get started, the officer in charge of this case was entered the courtroom, and I would ask for an exception to any motion to sequester witnesses that she be allowed to stay as the officer in charge.
The objection, Mr. O'Donnell?
We just go off the check. No objection for the purpose of the preliminary exam.
All right, thank you. All witnesses will be sequestered. There will be an exception for the officer in charge of the case.
Thank you, Judge.
You're welcome.
Would you please state your name for the record?
Jessica Watkins.
And Ms. Watkins, we're all having to wear masks and speak into microphones, so I want to make sure that you speak loud enough for everyone to hear you and clearly if possible. And just remember, if it's a yes or no, to say yes or no instead of or because as the judge pointed out, we do have a court reporter who's taking down everything that's said today. Okay?
Okay.
And Ms. Watkins, how old are you?
17.
And do you know Darius Watkins?
Yes.
Who is he to you?
My brother.
Excuse me, Your Honor.
And Ms. Watkins, your brother Darius, if you look around the courtroom, do you see him in the courtroom today? And you can stand up if you have to.
Yes.
And can you tell us where he's seated and what he's wearing?
Behind the wall in the green.
Your Honor, I would ask that the record reflect that he has identified the defendant.
The record will so reflect.
Thank you. I want to talk to you about the day of February 21st, 2020. Do you recall where you were that evening?
Yes.
Where were you?
My grandma's house.
And where's your grandmother's house located? What city is it in?
Detroit.
And that's here in Wayne County?
Yeah.
And who was at your grandmother's house when you got there that day?
When I got there, it was my grandma. It was just my grandma. And then my brother came, then my auntie came.
Okay, now what's your grandmother's name?
Jardine.
I'm sorry?
Jardine Watkins.
And what's your aunt's name?
Alicia Watkins.
And you said then your brother was there, and what brother are we talking about?
Darius.
Now, do you normally stay at your grandmother's house?
No.
And why were you there?
Because she asked me to come over.
Yeah, so what was the plan for when you went over to your grandmother's house?
Just to stay with her because nobody here at the house with her. So she wanted me to come over. I was going to spend the night and then leave in the morning.
Okay. Now you had said, because no one was going to be there with her, but you had told us that your aunt and your brother were there. Were they there when you got to the house?
No,
So the plan was for you to spend the night there?
yeah.
And tell us about when you got ready to go to sleep. What was going on?
I was laying there and the TV was off and I was laying in bed and I was face to the right.
Okay. Now, when you were laying in bed, what room were you in?
I was in my grandma's room.
Was she in there with you?
No, she slept in the other room.
And so was anyone, when you went to bed that night, was anyone in the room with you?
No, not when I lay down.
At some point, was somebody else in the room?
Yes,
And who was that?
Darius.
And were you expecting the defendant to come in there with you?
No,
Were you asleep by that time when he came in?
I wasn't asleep, but I was like dozing off, but I wasn't fully asleep.
What do you remember? How did you first notice that he was in the room?
Cause I started hearing somebody move around and they like taking clothes off. So that's how I heard somebody was in the room.
And could you see what he was doing?
No,
And what happened after you heard this where it sounded like someone taking clothes off?
I was still laying down and then I felt somebody get in the bed.
And was anything said at that time?
No,
What were you thinking?
I was just thinking it was probably my auntie that she just came home and she got in bed. I wasn't thinking it was somebody else.
Now, you said it was your brother. How did you determine that it was your brother?
Cause I know it was a mustache.
Okay. And tell us what happened when he got into bed with you. What do you remember first?
So I was laying down and I was face to the right, face to the window, and I felt somebody pulling down my shorts from my pajama, and pulling down my panties.
And at this point, was there any conversation?
No,
What did you do?
nothing, I laid there.
Okay, and then what happened?
I felt somebody rubbing on my butt.
And
And then
let me ask you this, when you say you felt somebody, at this point, did you know who it was?
yes, I know who it was.
And who was it?
Darius.
Now, when he was rubbing on your butt, what did you feel?
Just thinking like what's going on, like, because I'm in a house with a bunch of family, so I was thinking what was going on, and
And physically, what did you feel when that was happening? On your body, what could you feel?
I was in no pain. I was in pain. Okay.
I'm sorry, I didn't hear you. Can
I
you
don't
repeat?
remember the feeling.
Now, this person, did it stop then? Was that person just rubbing on your butt?
No.
What happened next?
And he pulled out his pants and he put my hand down there.
Okay, and you said, can you put your hand down there?
Yeah.
And what happened with your hand?
He was moving my hand up and down.
Doing what? Let me ask you this, was your hand touching anything?
Yeah.
What was it touching?
His hand.
Okay. And did you want to do that?
No.
Okay. And did it stop there?
No.
Okay. Tell us what else happened.
After that, then he got between my legs and put his hand in my vagina. He kept doing that.
And did you want that to happen?
No.
What were you doing at this point?
Facing the window. My face was facing the window, but my body was straight.
Okay. And did it stop at that point after he put his finger in your vagina?
No.
What else happened?
Then he put his mouth on my vagina.
And did you want that to happen?
No.
At any point while this was happening, did he say anything to you?
No.
And did it end here?
Yeah.
At any time, did any other part of Darius's body touch any other part of your body?
Yeah.
Tell us what part of your body touched what part of your body.
His hand touched My butt.
And Ms. Watkins, when you tell us that Ms. Penis touched your butt, what do you remember physically feeling when that happened?
Judge, may I interrupt for one moment?
Sure, go ahead.
My question is, may I give my client pen and paper?
You may.
I just want to make sure you're okay.
Yes.
I'm sorry, could you repeat that?
I'm going to show you. Ms. Watkins, when you felt his penis, you said you felt his penis on your butt, or he touched his penis to your butt. Was it on the outside of your butt, like your butt cheeks? What area are you talking about?
No, trying to put it in a hole.
Hey, could you feel that?
Not really, because it wasn't going in.
Okay, but at least from what you're saying, he tried to put his penis in your anus.
Yes.
And it did touch that part of your body.
Yes.
Was there any other part of the defendant, Darius's body that touched your anus?
No.
And was there any other part of your body where the defendant, Darius's penis may have touched your body?
No.
What, at any point, what do you remember happening? Like, how, did anyone at any point ever come into the room?
Yes.
Who came in the room?
My auntie, because it was the morning time, and she was getting ready for work, and she actually came in the room and turned on the light. But like, he kind of like hit on top of me. They got big covers in my grandma's house, so they wouldn't know that he was in there.
Objection as to what she's speculating regarding what someone knows.
Sustain.
Okay, so at this point, when your aunt turned on the light, where were you?
I was still in the bed.
Okay, and where was the defendant?
In between my legs, but he was like on me, like he laid on me, so he was like hide a little bit, so she didn't know that he was in there.
Okay, so his body was laying on top of your body.
Is that a yes, ma'am?
Yes.
And so after your aunt came in and turned on the light, did she stay in the room?
No. She got her clothes and stuff, and then she went in the bathroom.
And then what happened then with you and the defendant? What happened?
Then he got up and got his stuff and went back down his room.
And, does the defendant live in that house?
Yes,
And where does he live in the house?
in the basement.
So when he got up and left the room, what did you do?
Laid there
And how were you feeling at this point?
in pain.
What was hurting you?
My vagina.
And at some point, did you get up or what happened?
After I stayed there for a while, then my auntie came in the room and I was crying and she was like, she asked me what was wrong with me and I just held up my panties and then she asked, did I pee myself? And I said, no. And I said, Darius. And she was like, Darius came in here and touched you. And I said, yeah.
All right, and at that point, did your aunt stay in the room with you?
No, when I told her, she went down the basement and asked him about it.
How do you know?
There's a vent in the room, so I can hear down the basement.
So you could hear what was going on down there?
Yes.
Okay. And from your aunt going downstairs, at some point, did you leave the house that day?
Yeah, I left the house when my auntie called my daddy, and my daddy and my mama came to the house.
All right. And what's your dad's name?
Watkins.
And what's your mom's name?
Shamika Watkins.
Okay. And once they got to the house, what happened?
Then he asked me what happened, and when I told him everything, and then when I told him that he tried to put his penis inside of me, that's when my daddy took me to the hospital.
All right. And I wanted to ask you a question. You had said that you were in pain by that time.
Yes.
And that your vagina was hurting.
Yes.
And did you tell that to the doctors at the hospital?
Yes.
Okay, tell us what happened at the hospital.
So, I was at the hospital and she gave me a swab and I told the detectives what happened.
Now, when you say that she gave you a swab, so did you have like an exam at the hospital?
Yes.
Okay. And where in your body did they do swabs?
My vagina area, my hands, my thighs.
Your side?
Yes.
Okay. And did they also swab you in like your anal area?
Objection leading.
I'll allow, you can answer that.
No.
You don't remember that?
Objection, she said no.
Sustain.
I have no further questions.
All right, we're going to take a brief break so that I can get some of these lawyers out, and then we'll continue with cross-examination. Ms. Watkins, you can sit in the hallway. We're going to take like a 10-minute break. Sir in Wayne County, what's your name?
That's Mr. Thompson, Judge.
And we need you to unmute yourself, Mr. Thompson.
Mr. Thompson, can you ask one of the deputies to come unmute you?
Mr. Nelson, are you ready?
Go ahead, say no.
Robert Thompson.
Okay, I think we're still waiting on the prosecutor.
Mr. Nelson, are you ready? Okay, as soon as the prosecutor is ready, we'll call your case, Mr. Thompson, okay?
Okay.
Thank you. Mr. Houston, who do you have? I'm sorry, Deputy, do you have anyone else there for my courtroom?
Yeah, give me 1 second. We have Irby and Leonard.
Irby is the co-defendant on Mr. Thompson. That's actually a problem.
And I'm here on Mr. Leonard.
All right, we're ready on Leonard.
Okay, I'll switch them out. Give me 1 second.
Thank you. Mr. Houston, who do you have?
Good morning, Your Honor. May it please this honorable court, Melvin Houston. I'm appearing on behalf of Donald Beauchamp.
All right, is Mr. Beauchamp in or out?
He is out, Your Honor. The matter is set for a in-person preliminary exam today, but I have to report to the court that I have had very little contact with Mr. Beauchamp. I've sent him 2 letters that were not returned. The first was sent in October.
And I'm going to call the case. Just 1 second until we get our prosecutor back in here.
I'm on this case, Judge.
Thank you. This is the people of the state of Michigan versus Donald Beauchamp, case number 20-F61028. Mr. Beauchamp is charged in count 1 with controlled substance delivery manufacturer. May I have your appearances, please?
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Okay.
And good morning, Your Honor. May it please this honorable court and your staff, Melvin Houston, appearing on behalf of Donald Beauchamp. My P number is 36280.
Thank you. Mr. Houston, you've had no contact or minimal contact with your client?
No, that is correct, Your Honor. I've sent 2 pieces of correspondence to Mr. Beauchamp. The first was October 17th of 2020. Both of those correspondences were not returned to me. So for that reason, I have reason to believe that somebody received them. The phone number that was provided by trial services is restricted or unavailable, is the way the message that I receive when I dial that number, what it states. That number, by the way, is 313-469-4571. So I'm at a loss as to how I'm to proceed without a client.
All right. When was the last time you spoke with your client?
I'm sorry, Your Honor, would you just repeat that?
Have you spoken to him at all?
No, I have not.
Okay, thank you. The court is going to, well, today's the date and time set for an in-person exam. We're unable to conduct that exam today. However, Mr. Houston has had no contact with his client, so the court is going to issue a warrant setting bond at $5,000 cash or surety. Mr. Houston, if you're able to locate your client, you can call my clerk and we'll give him a ring on the warrant.
Will do, Your Honor. Thank you very much.
Thank you.
Thank you, Judge.
Thank you also, Ms. Ripley.
Thank you, Mr. Houston.
Okay. Stay safe, everyone.
Thank you. You too. Sir, in Wayne County, if you can unmute yourself and tell us your name, sir. Can you unmute?
Kendall Leonard.
Thank you. This is the people of the state of Michigan versus Kendall Leonard, case number 20 F62259. Mr. Leonard is charged in count 1 with assault with intent to do great bodily harm, less than murder, or by strangulation. May I have your appearances, please?
Morning, Your Honor. Brittany Johnson on behalf of the people.
Morning, Your Honor. John Goldberg appearing on behalf of Mr. Leonard with respect to this particular matter, P30758. Mr. Leonard, would you please put your name on the record?
Kendall Leonard.
Thank you. Your Honor.
Go ahead.
Your Honor, this matter was previously set before Judge Archer. Yes, we received. I requested a DSU with an exam date that was previously set in Judge Archer's court for the 28th of January. Mr. Leonard has been incarcerated in Wayne County Jail, as you can see. The court indicated at that time, Judge Archer's court indicated that if we got the DSU report back, I had requested some changes in the conditions on bond. If we got the DSU report back, that it would be set up to be reviewed regarding my request for bond condition changes. Subsequently, I never received the DSU. It's my understanding from our discussions yesterday that the matter had been referred to your court, and we appeared yesterday. You also indicated, the court also indicated that they had received a copy of the DSU, but were unable to forward that to me. Subsequently, I've been informed that this matter is now before this court and has been transferred from Judge Archer's court because you have another matter, which was prior to Mr. Leonard's previous case I now have before him. So I guess we're here, one, to get Mr. Leonard into the proper court, and two, to review the DSU report regarding my request for the changes in the bond.
Okay, thank you. The court is in receipt. Did you want to make a bond argument, Mr. Goldpaw?
I would like to know what the, I have not had any information as to what the report indicated, Your Honor. If the court could.
Absolutely. The court is in receipt of the pretrial investigation summary. His current bond is a $2,500 cash surety 10% bond with a GPS tether. And the recommendation from the writer of the report, who is Catherine Campbell, is that there be no action on the present bond and no contact with the complaining witness.
Okay, I understand that, Your Honor. I guess the request we were making was to give her a personal bond with the tether. However, I understand that that recommendation has not been granted. And so there'll be no further argument with respect to that. When we were last in court, Your Honor, back in front of Judge Archer, I had related to the court that Mr. Kendall Leonard is the owner of the home. The alleged victim, has now vacated the home, and so he would be able to go back to his at least location. With the concerns with COVID, et cetera, we felt that this would be more appropriate. Clearly, he understands no contact. The other indication that I received is that, and I've spoken to Mr. Leonard's mother, that those conditions, and they have been receiving some threats from the victim, but I've told her she should contact the police regarding that. With that said, Your Honor, I would assume that we still have an exam date set live coming up in this particular matter.
Okay, thank you.
And I believe, Your Honor, we addressed that issue yesterday as well.
All right, so we'll schedule this matter for an in-person exam to occur on the 20th. Oh, that was that. Let's do it on. Our calendar. Okay, are you available on Friday? The 29th?
I can check, Your Honor. Let me check my calendar. Your Honor, I am scheduled for 2 live exams on that date. They are in Judge, check here, I believe, yes, Judge King's Court. One is at 11:45. One is at 11:30.
All right, so why don't we schedule this for an in-person exam to occur at 10 a.m.?
10 a.m.? That'll be fine, Your Honor.
All right. So Mr. Leonard, we'll see you on this case next Friday, the 29th at 10 a.m.
Thank you, Your Honor. Mr. Leonard, I'll come down and we'll talk.
Mr. Gopal, do you happen to have discovery yet?
I have the discovery. However, I don't believe I have any digital discovery if it exists. So if you could send the discovery to me again, I would appreciate it.
No problem.
Okay, because it's kind of blurry. Thank you, Ms. Jones.
Thank you.
I'm sorry, Ms. Johnson, correct? Thank you.
Thank you.
Mr. Nelson, are you ready?
I am ready, Your Honor, although I've been in contact with Miss Maribel. She said, oh, it looks like she is on, yes. So I am ready.
All right, let's do Thompson first, please. Debbie, we're ready on Thompson. Ms. Watt, who do you have?
Good morning, Your Honor and staff. I was contacted by assigned counsel on a Roderick Martin.
Okay, we'll do Mr. Martin. All right, Mr. Martin, take that thing off your head. Thank you. This is the people of the state of Michigan versus Roderick Martin. We may not have our prosecutor. Is there a prosecutor involved? Is this your case, Ms. Johnson?
Yes, Your Honor.
Oh, that's right. Thank you. This is the people of the state of Michigan versus Roderick Martin. Case number 20 F62255. Mr. Martin is charged in count 1 with assault with intent to do great bodily harm less than murder or by strangulation. Count 2 is a misdemeanor. Your appearances, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people.
Good morning, Your Honor. Coral Watt appearing on behalf of Roderick Martin.
And good morning, Your Honor. Matthew Evans on the prior counsel. I'm moving to withdraw.
All right, thank you. Mr. Martin, state your name for the record. Unmute yourself, sir.
Roderick Martin.
All right, thank you. Mr. Evans, you can no longer be on this case because you have new employment. Is that correct?
That is correct, Your Honor.
Your Honor, I'm sorry. I just want to make sure that Mr. Evans puts his contact information in the chat room before he logs off.
Mr.
His
Martin?
telephone number. I need to call you on the case.
Oh, my telephone number. Okay.
Yes.
Yeah, no
Thank
problem.
you, Your
In
Honor.
accordance to allow Mr. Evans to withdraw from the case, Ms. Watt is now assigned to the case. Today's the date and time set for a probable cause conference. Ms. Johnson, is this the first PCC?
Your Honor, I'm not sure.
It is not.
Okay, thank you.
Thank you. So, Mr. Evans, if you can provide the discovery that you have, if you have discovery on this case, Ms. Watt, that would be appreciated.
Yes, I believe I do have discovery here, so I will get it to her.
And the court is going to schedule this matter for an in-person exam to occur on June 23rd at 9:30.
Thank you. June 23rd at 9:30. That's the PCC, Your Honor, or an exam?
Exam.
Okay. Is there any contact? Mr. Evans, do you have contact information for Mr. Martin?
I believe I have his phone number. We talked a couple days ago.
Mr. Martin, can you please give Ms. Watt your number now?
313-740-3284.
Thank you, Your Honor.
All right.
Thank you, Mr. Martin.
You are.
This matter is concluded. Thank you.
Have a great day, everyone. Bye-bye.
You too.
All right, I would like to do both Mr. Irby and Mr. Thompson, and then I need to get back into my exam.
Judge, I will confess I do have a somewhat lengthy bond argument, so I don't know if you'll have time for it.
Mr. Baker, Ms. Hendling is not back.
Your Honor, could you just repeat her name? I couldn't hear you too well. Who is it?
Tara Hendling, she's not back yet on your case.
Okay. Your Honor, okay. I'm going to come back in. If for some reason I don't, I mean, I will of course come back in, but anytime if I can just get a quick phone call, that'd be great. I mean, I'm on the phone, so I can't make phone calls and be on the Zoom at the same time. So I apologize. Understood. Thank you.
Your number? Your number?
Oh, yes. 313-623-8247.
And Your Honor, Ms.
Thank you.
Hindling said that she had to step out to a Wyandotte PCC, but she can be right back whenever I text her.
Can she come back like right now?
Yep.
Okay. I'm going to stick around, Your Honor.
Judge, you're ready for both those guys?
Turn it off. I got it.
Yes, sir.
Those things you got to do it where I can hear. Okay. I didn't do it. I'm on here now. Turn it off. Take it.
Judge, Mr. Irby, you're ready.
All right. Do you have both or just one?
I have both of them, just Irby's in the restroom right quick, so he'll be on one side.
And Your Honor, I'm here for Irby.
Yes, I know, thank you.
Good morning. Okay.
have any other lawyers out there for exams impersonation?
Pardon. Ms. Carson? Yes. Do you have any other attorneys out there for exams outside?
Do you have any other jailers on your list?
Who I have is, we got Van and, that's Vince.
Oh.
These other two are for afternoon, yeah.
Okay, thank you. All right, this is the people of the state of Michigan versus Darnell Irby and Robert Thompson. Case number 21 F55095. Both defendants are charged in counts 1 and 2 with assault with intent to murder. Counts 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation. And in counts 5, 6, 7, and 8 with weapons felony firearm. Mr. Irby is charged in count 9 with weapons carrying concealed. And Mr. Thompson is placed on notice that he is a habitual offender second. May I have your appearances, please?
Good morning, Your Honor. Mr. Nelson Jr. on behalf of the people, 78306.
Thank you. On behalf of Mr. Irby.
Good morning to this honorable court. Carla Marable on behalf of Mr. Irby, P number 62755.
And good morning, Your Honor. From Neighborhood Defender Service of Detroit, Jonathan Hortis, P78948, on behalf of Mr. Robert Thompson, who's appearing via Zoom from Wayne County Division 2.
Thank you. Mr. Irby, can you please state your name for the record? And Mr. Thompson, if you can please state your name.
Robert Thompson.
So today's the date and time set for probable cause conferences in both of these matters. Ms. Marable, how would you like to proceed?
Your Honor, we would like to set it for a preliminary exam. I have the discovery for the case, so I'm ready for a preliminary exam.
And I would join in that request, Judge, for Mr. Thompson. We have discovery and are ready to proceed.
All right, great. It's my understanding that Mr. Portis, at least you would like to address the issue as to bond, is that correct?
Yes, Judge, and unfortunately, it's going to take a little bit of time. There are videos that I need to show the court as part of my bond argument.
And I also want to address the issue of bond.
It shouldn't take that long. I think I can keep it within a couple minutes, but it's necessary for the bond argument.
Okay. All right, go ahead. We'll start with you, Ms. Irby. I'm sorry, Ms. Marable, go ahead.
As for bond?
Yes.
Your Honor, my client has no prior criminal record whatsoever. He has very strong family support. And I do understand that bond is a two-prong, is to ensure that you show up for court, which I don't think that there's an issue with that. He has no prior record, no history of capias. He has a retained attorney. So, and he wants to fight this case. As for society, he's not a threat to society. I think this is a incident that is singular by itself, and that he's not a threat to society. If Your Honor wanted to ensure you could also have a tether, we're just asking for, we know that we won't be able to get a personal bond because of the allegations, but something reasonable. He does work, and he is trying to get back to work because he does have substantial, financial things, and he's also expecting his first child. So we just asked for a 10% provision of the bond, Your Honor, which is still substantial.
All right, thank you. So the court is in receipt of, I'm sorry, I didn't have Mr. Nelson, go ahead.
Thank you, Your Honor. The people would be opposed to any reduction in bond at this time for Mr. Irby. This is a two-defendant case. I would, without arguing too many of the facts, I would point out that only one of these two individuals actually fired a weapon, and that was, in fact, Mr. Irby. That shooting is caught on video. I believe Mr. Hortos may be showing a little bit of that video in a few moments. But Mr. Irby is a shooter in this case, and although he does not have a prior criminal record, he did jump into the deep end of the pool with assault with intent to murder charges. He did fire numerous shots at the complainants as they were running away from a physical fist fight that was started by Mr. Thompson. So the complainants did not seek out this confrontation. They did not seek to engage it and actually were running away when they were shot. So the people do feel that Mr. Irby is a danger to the community. And given the charges, I believe his bond is set at $100,000. That is a reasonable bond considering these charges, Your Honor, and just merely due to the fact that it is out of Mr. Irby's financial means to make that does not make it an unreasonable bond. So therefore, the people would be opposed to any reduction in charges or in bond at this time.
Thank you. All right, so the court has had an opportunity to consider Mr. Irby's bond, which is $100,000 cash and surety with a GPS tether. The court has listened to his lawyer, Ms. Marable, as well as the prosecutor, Mr. Nelson. And I've also taken into consideration the charges for which Mr. Irby stands accused, as well as the pre-trial investigation summary that the court had an opportunity to review. It does indicate that Mr. Irby has a failure to appear history for some, it looks like traffic matters within Detroit and East Point. It also indicates that he has a current case that was dismissed for probation, a CCW case that was dismissed on October 3rd, 2017. It was closed. Looks like there was a failure to appear for show cause hearing on January 23rd, 2017. And then on October 3rd, the probation was closed and the case was dismissed. There also appears to be some contact out of Kentucky. January of 2019, there's an aggravated trafficking in controlled substance. There's no disposition that's available, and that's out of Fayette County, Kentucky. And then there's another charge of drug paraphernalia, fire, possess, which is a misdemeanor out of Kentucky. He's not on probation or parole. The recommendation from the writer of this report was that there be no action to reduce the present $100,000 cash or surety bond. Taking all of that into consideration and the serious nature of the charges for which Mr. Irby stands accused, the court is not going to find that his bond is excessive. I'm going to leave it as it is at this time. Mr. Hortels, if you'd like to address Mr. Thompson's bond at this time.
Yes, Judge. So before I I'll play the video last. I'll just indicate that my client does have ties to the community. I've been in communication with his brother, who's been supplying me with some additional information about the case. My client would be residing at the Whittier address that I believe the court has on file, and he would be living there with his mother and brother if he were released, and they could assist in securing his appearance. That they've already expressed an interest in tracking this matter, understandably. While I do acknowledge that Mr. Thompson has that prior conviction, ultimately, I think that bears somewhat little weight on this case. It's not really related, in my professional opinion, at least. My client has been in contact, is currently on probation. That's something that we have to acknowledge, but he has been in communication with his probation officer, who I believe is Miss Jefferson, and works off of the Algonquin office near the intersection there. My client does have a learning disability. He is dyslexic, and in high school and through middle school, he attended special education classes. And I think the court can sort of get the sense of some of the difficulties that he faces by just listening to him. And it's something I think the court should consider with the totality of the circumstances. I would ask at this time to play some select portions of the video evidence that I've received from the prosecution to speak as to the likelihood of conviction for Mr. Thompson. by way of background, the complaining witnesses in this case, or at least one of the complaining witnesses, stole Mr. Thompson's phone. Now, maybe the prosecution will disagree with me on the language usage there, but without playing the entire video, I'll summarize that Mr. Thompson goes into a gas station, drops his phone on the floor, or somehow it comes to not be in his possession anymore. One of the complaining witnesses picks the phone up off the ground and refuses to give it back to Mr. Thompson. You can see them sort of like arguing back and forth in the gas station. My client, Mr. Thompson, leaves the gas station, goes to the red Burgundy, I believe it's an Impala, and to address Mr. Irby to ask him, you would presume for help. You can't, there's no audio on the video. He then returns with Mr. Irby right behind him to the front of the store, enters the store. The one man who picked up the phone and a friend of his both go out those doors, and there's a sort of like argument that ensues, and you can see both people pointing at the phone saying, basically, you presume, give me back my phone. It's only after these people say something in return to Mr. Thompson that Mr. Thompson swings, goes for a sucker punch, no denying that, on one of the complaining witnesses, and it's at that point that the shot rings out. So I'll play the video to show you sort of the sequence of events, but that's the background. And I think in light of that, it has a pretty strong bearing on Mr. Thompson's culpability with respect to the aiding and abetting theory. So let me see if I can get that going.
And I've been able to screen share.
Okay, Judge, can you see that all right?
Yes.
Okay, so just before I play this video, I'm at 6:49:13 on that video. This person standing in front, I believe, will be identified as Mr. Thompson at the preliminary exam, and then this is Mr. Irby behind him. I'm just going to press play. So you can see them going into the store after having Mr. Thompson already had his phone taken. He's going to confront the other two about getting it back. If the court wants to see the other angles, I can play those. It just will take more time. So you can see Mr. Irby pointing at the guy that's got the phone. It's this gentleman right here. Says something back to him, gets punched in the face. And it's only then that the gun is drawn and the fight goes off camera. So I'm not sure how much more the court would want to see of that. I can play the internal part of the gas station footage where it shows the complaining witness taking Mr. Thompson's phone. But ultimately, in order for the people to succeed on proving Mr. Thompson guilty of this crime, they have to prove that he knew that Mr. Irby had a gun, that he knew that, he was either knew or encouraged him to produce the gun and use it as part of this, fight, or that, assault with intent to murder was a likely or natural or probable consequence of starting a fight. And I don't think that follows. There is case law out there indicating that a aggravated assault or a great bodily harm can be elevated up to a murder type charge where that's a natural and probable consequence. But throwing a sucker punch at somebody doesn't necessarily warrant or for one to expect that a gun is going to be produced and that someone's going to get shot or shot at. Ultimately, you can see that Mr. Thompson is engaging in a kind of claim of right argument by trying to recover his property. These thieves are not returning his property when he demands it. And ultimately, he reacts in a way that he should not have reacted by throwing the punch, but one that is very human and very understandable. I think it's an extreme stretch, and I don't know how the people are possibly going to succeed on this case at trial, considering that I'm going to crucify these complaining witnesses for stealing from Mr. Thompson and then trying to say that basically they're innocent, on the follow-up. Mr. Thompson obviously didn't do the right thing by swinging the punch, but you can't really say that he's going to be convicted of assault with intent to murder because of what someone else did. And proving that he knew that was going to happen is going to be impossible.
Thank you. I'm quite familiar with that theory. As a prosecutor, I had a case that charged someone similarly. So, is there anything else that you'd like to say, Mr. Nelson?
Yes, and despite Mr. Hordos's anticipation of crucifying witnesses, I I guess I would point out, and I don't have the video queued up, ready to go. I would point out a few things that when you look at the entirety of the video from different angles, we see Mr. Thompson leave the store, walk over to the burgundy Impala where Mr. Irby is sitting in the driver's seat. And it's been a couple weeks since I've looked at the video, so I'm going off my recollection. But Mr. Thompson approaches the driver's side where Mr. Irby is seated and holds out his hand as if asking for something, asking for an object. And as Mr. Hordos points out, there's no audio in this video, but it appears that when I looked at that video, it appeared to me that Mr. Thompson was walking over there asking for something. And instead of handing it over, it appears that Mr. Irby kind of says, hey, I'll come along. Mr. Irby gets out of the car, and they both enter the store. Within seconds of entering the store, they leave the store. And that's when the dispute over the phone begins. As you saw, that dispute lasted, I don't know, probably about a second and a half before Mr. Thompson threw the sucker punch. And what turned into a dispute quickly escalated into a fight, which quickly, within 30 seconds after that, escalated into a shooting. So, Your Honor, given the fact that Mr. Thompson walked over to Mr. Irby, who had a gun, and appeared to ask for an object, it appears to me that the aiding and abetting theory will stand up, at least to be put forth to a trier of fact. And so I think that an aiding and abetting theory on assault with intent to murder with that video that you just saw is a reasonable charge to make. And as such, I would make the same argument that I made with Ms. Maribel's client, that just because a bond may be out of reach to Mr. Thompson doesn't mean that it's an unreasonable bond. $100,000 on a assault with intent to murder charge is a reasonable bond. So the people would again be opposed to any reduction in bond at this time.
All right, thank you. So the court has had an opportunity to consider Mr. Thompson's current bond, which is $100,000 cash for surety with the GPS tether. I've listened to the argument of his lawyer, Mr. Portals, observed video in the case, and also have an understanding of the theory of the case as it relates to Mr. Thompson, him not being a shooter. The court has also listened to Mr. Nelson, the prosecutor in the case. I've taken into consideration the charges for which Mr. Thompson stands accused, and I've reviewed a pretrial investigation summary where it indicates that Mr. Thompson did have a prior case for assaulting, resisting, or disrupting back in 2019. It looks like he may have one failure to appear, but that was during the pandemic on a driving while license suspended case. The recommendation from the writer of the report, who is Lawrence McDonald, is that there be no action to reduce the present bond. The court is, based on the information that I've witnessed and observed, find that the current bond is excessive. I'll make it $100,000 10% bond with the GPS tether.
Judge, what was that amount? I couldn't hear you. It broke up.
I'll add a 10% provision to the bond.
Understood, Judge. Unfortunately, I'm afraid that is still going to be outside of Mr. Thompson's reach. Ultimately, $10,000 is a lot of money. I understand, obviously, the court is balancing sort of what it perceives as the risks. But to acknowledge an earlier point by Mr. Nelson, I think that the factor that the court has to consider most is the likelihood of conviction at trial, not just likelihood of bind over. While they may be able to succeed in their bind over argument, which I wouldn't concede in any fashion, a jury's going to hate these complaining witnesses. And I think the criminal culpability of Mr. Thompson is significantly attenuated. At most, they're going to get him on a simple assault, if that. Considering those things, I think Mr. Thompson has every reason to come back to court. And he shouldn't be held in jail on $10,000 that he doesn't have.
All right, thank you. So the court has made its finding. I will reconsider the bond after having heard the evidence in the case. This matter is scheduled. You guys have an exam date already?
No, Judge, we were waiting for you from that.
We need an exam date.
Thank you. The court will schedule this matter for an in-person exam. Is it already on Friday? We'll set it for next Friday.
Your Honor,
yes.
If we may, I can't. I will be out of town on the 29th. Because you're scheduling for next Friday, which is the 29th, correct?
Yes, ma'am.
I will be out of town from the 28th until February 1st. Can we have another day?
Other days. What about, can you come on the 27th?
I have a number of things on the 27th on Zoom, but I try my best. Can we have it at a specific time?
Yes, absolutely. Mr. Nelson, are you able to get your witnesses by the 27th?
I will get subpoenas out today. I mean, that is, I guess, a little bit of short notice, but I will do my best. If I have any problems, I'll let everybody know.
Judge, I don't think I can do the 27th. I'm sorry.
Okay, so then we're gonna have to schedule this. Yeah. I can set it for, we can do February 2nd, maybe?
At February 2nd, at what time?
10 a.m.
Okay.
That works for me, Judge.
That's good for me.
All right, so we'll see you all February 2nd at 10 a.m. on our.
And this is an in-person exam, correct?
Yes, ma'am.
Okay, thank you, Your Honor.
All right. Thank you, Judge.
All right, I'm gonna do one more, and then we're bringing up, I gotta finish my other case.
Your Honor, Ms. Hindling did have to step back out to that other meeting, but she said that Laura Nersesson is in the waiting room, so she'll be able to cover.
I'm actually here. Thank you.
Thank you. I just admitted.
Judge, you want me to bring out Antoine Johnson?
Johnson. I think you're giving me extra.
Antoine.
Oh, no, you're not. No, you're not.
Okay, I was gonna say, I thought I seen him on the docket, but.
We have not heard from his lawyer, Mr. Perkins. We'll call Mr. Perkins. You can bring him, or actually, can you call back? Can you call back at like 12:15?
You want me to call back at 12:15?
Yes, please.
Yeah, that's fine.
Okay, thank you.
You're welcome. Bye.
This is the, I have Porter. Okay. This is the people of the state of Michigan versus Daryl Porter, case number 20 F61959. Mr. Porter is charged in counts 1 and 2 with criminal sexual conduct 3rd degree. Your appearances, please.
Laura Nursessian on behalf of the people. Good afternoon, Your Honor.
Good afternoon.
May it please the court, Your Honor, Tyrone Baker appearing on behalf of Mr. Porter. P number 62647, Your Honor. Good morning.
Thank you. Mr. Porter, state your name.
Daryl Porter.
Good morning.
Good morning.
Today's the daytime the first probable cause conference. The court is going to adjourn the PCC to February 18th at 8:30 a.m. Mr. Vicker, do you have discovery?
It's my understanding, I just received email. It's my understanding that it's just been sent. So that's apparently I'd have to check it, but I take their word for it, Your Honor.
Yes, Your Honor. I sent it via evidence.com a few days ago.
Okay.
All right, very good. Then we'll see you back for a continued PCC on February 18th at 8:30 a.m.
Yeah, I'm sorry.
Actually, Your Honor, there is a matter I need to raise. It's a matter of bond.
Go ahead.
It's my understanding that the defendant's bond is $2,000. This defendant is charged as a habitual fourth offender with a prior CSC, a CSC second. And it's also my understanding that when he was taken into custody, he called the victim's father, who is also his father, admittedly, but also in that phone call was requesting, if not demanding, that they drop the case against him. We do believe that as such, the bond is woefully low given the charges that we have at hand, his prior history of criminal sexual conduct, the fact that he has a habitual fourth, I mean, this is a life offense at this point, and that he's making contact to not only with the family, but also to drop the case.
Mr. Dicker?
Yes. Well, the first thing is, if I'm understanding Madam Prosecutor's argument, is that there was an initial call when my client was taken into custody when he was in the jail or in police custody. Is that what's being put forth?
Yes.
Okay. So, Your Honor, again, at that point, my client hasn't been instructed to have no contact. There's been no instructions. There's been no bond conditions. There's been nothing placed on my client at that time. He's been taken into custody, told an accusation. Of course, I haven't heard the tape, so I'm not in a position to speak as to what's said or not said, or even whether it exists. But I would just indicate that at that point, my client hasn't been instructed by the court to do anything or not do anything. So I think that that's important. Since the time that my client has been released on bond, I don't hear any allegation that my client has violated any court order as relates to his bond. And he's here, as he's supposed to be. So the purposes of bond to protect community and to ensure his appearance so far seem to be working just fine, Your Honor. And so for those reasons, I would ask that the bond remain the same. And if such time that there were some kind of bond violation, which there clearly is not even an allegation that there has been, then we could address that issue at that time. But at this point, Mr. Porter's doing what he's supposed to be doing. He was released on bond, and he's here, and he's not having contact. So that's what the court ordered him to do, and that's what he's doing.
Well, I would stress that even though there was no, at that point, there were no requirements of bond or even a bond in place, anyone would know you don't call a victim family and say, drop the case.
No,
I would also just, I will further add that the people aren't just simply relying on that phone call, but the fact that this is a life offense where of a CSC and that there is a prior CSC, he is a danger to the community. And we had to have him extradited here from Chicago for him to appear in court and face these charges.
Your Honor, I'm very certain that everything that was just stated by Madam Prosecutor was stated to the magistrate when this bond was set, especially whether he was or was not extradited. I don't know the facts of why or how Mr. Porter became extradited. I don't hear any allegation that he ran off. I don't know why he was extradited, Your Honor. In fact, I was just sent the discovery as was indicated. So, Your Honor, I think at this point, this would be a premature situation. At the end of the day, Mr. Porter, the statement that anyone would know, we don't go by what people, anyone would know. We go by court orders. Mr. Porter was ordered not to have contact. He hasn't had contact. Mr. Porter was granted a bond and he made the bond.
Thank you. All right. Thank you. The court has heard from both the defense and the prosecution in this case. The court will adjourn this matter to February 18th at 8:30 a.m. Mr. Porter, we'll see you over Zoom on that date and time. You're to have absolutely no contact whatsoever with the complaining witness in this case. And you do have a GPS tether, correct, sir?
Oh,
All right, the court is also going to order a GPS tether to be placed on Mr. Porter. So no contact for the GPS tether.
you said what?
The Wayne office will contact you when you're supposed to get fitted with the GPS tether.
All right.
Thank you.
Mr. Porter, I sent you my phone number on the chat. You need to call me at that number.
Where I go to?
To where it says more. And there should be a little red number.
Just give them your number. Or Mr.
Oh, that's fine.
Porter.
Write it down, Mr. Porter.
What is it?
Just 313-623-8247.
All right.
Thank you, Your Honor.
Okay. So Mr. Kuja, and is that Mr. Arms?
Yes, it is.
Okay, you have to call back at 12:15. I have an in-person exam that I'm trying to conclude.
Okay.
And so, yeah, so just call back at 12:15 and we'll handle your matter.
Yeah, for me, Judge, call back in at 12:15?
Yes,
okay,
sir.
I'll do that. Thank you.
Thank you.
Right, bye-bye.
We're ready for
Your
this.
Honor.
We have a gentleman outside with Larry Gilbert, and he came to court because he couldn't get his phone to work. I think he was supposed to be by Zoom, but he's been waiting outside for like at least an hour now. I don't know really, we don't really know what to do with it.
What's Mr. Garrett's attorney?
I told him he didn't have to be here.
You can.
He had issues with his phone, and so he couldn't.
Can't zoom in,
Yeah, his lawyer.
It's in the, I don't know.
Yeah, he'll have contact. If you can just get his phone number, we'll make sure that's clear.
Okay.
And we're ready for Mr. Watkins and Ms. Watkins.
Go ahead, I got it.
Look at the witness.
Shit, well, you found it.
Yeah.
All right, we're back on the record in the matter of Darius Watkins. Ms. Watkins, you remain under oath. You understand? Okay, thank you. Mr. O'Donnell, you can start your cross-examination of this one.
All right, again, it's James O'Donnell, P42585, from the Neighborhood Defender Service, on behalf of Mr. Darius Watkins. Good morning, Ms. Jessica Watkins.
Good morning. Good morning.
You know that I'm going to be asking you some questions.
Yes.
If I should ask a question that either puzzles you or for some reason you don't understand, will you please tell me the state of the question again?
Yes.
All right, thank you for that.
Yeah.
You know that you just earlier today took an oath to tell the truth, correct?
Yes.
And do you know that if you don't tell the truth, that could be a crime?
Yes.
A crime of perjury.
Yes.
When did your grandmother ask you to come over to stay with her? Was it the day that this happened or the day before?
No, the day when it happened.
Do you remember telling a person who questioned you at the Kids Talk video that she called you the night before?
No.
When you got that call, were you at home?
Yes.
And after you got the call from your grandmother, did you know that you were going to be going to her house?
Yes.
And after you knew that you were going to go to her house, did you call anybody and tell them that you were going to your grandmother's house?
No.
If you made any calls to anybody about the fact that you're going to your grandmother's house, would that be on your cell phone?
Yes.
Did you own a cell phone?
Yes.
So your statement today is that after you decided to go to your grandmother's house, you told no one, either personally or by phone, that you were going to your grandmother's house.
Maybe my mom knew because I was next to her while I was on the phone, so she knew.
Beyond your mom, who was in the next to you while you were on the phone, did you tell anybody else?
No.
You said that you got to your grandmother's house about what time?
Probably like 8, 9, 8.
Okay, 8 or 9 in the evening, correct?
Yeah.
And who did you see in that home when you got to that?
When I got there, it was only my grandmother.
At what point in that evening did you ever see Darius come into the house?
Yes, I opened the door for her.
And what time was that, if you know?
I don't know.
Well, was it after you went to bed? Or was it before you went to bed?
That was before.
When you're at your grandmother's house, was there anybody else sleeping on the same floor as you?
Yes, my grandma.
And she's in the same hallway you're on?
Yes.
How far is her door, the door to the bedroom where she was sleeping in, from the door to the bedroom that you were sleeping in? So it's right across from each other?
Yes, right across.
And your door was open through the entire night, correct?
Yes.
Do you know if your grandmother's door was open?
No.
Do you know if your grandmother is a light sleeper or a heavy sleeper?
I don't know.
Now, something happened during the night. That's what you've come here to tell us about. Do you know what time those things that you've described happened?
I don't know what time it happened, but I know what time it ended.
Well then, what time do you think it ended?
It's like probably like 6, 7 in the morning.
And how did you know that?
Because it was light outside.
Did you ever look at a clock and then to yourself say, oh, it's 5 o'clock or 6 o'clock or 7 o'clock?
No.
So it was fair to say you don't know the actual time that it ended.
Yes.
All right. Now I'm going to ask you what might be a difficult question, and I'll accept your answer. Do you know how long these events you described took place? In other words, are we talking about something that took 2 hours, something that took 10 minutes? I'm open to any answer, but you're the only one who can give that answer.
Yeah, I don't really know how long it took.
So the answer to the question, what time was it that someone climbed into your bed, is that you don't know.
Yes.
Do you know, is there a clock in that bedroom?
I don't know.
You never saw it?
No.
The bedroom was dark, correct?
Yes.
Was there a light on in the hallway?
No.
When this person came to your bed, you said did you hear something before the person sat on your bed or got into the bed?
Yes, like they're taking their clothes off. I heard the belt buckle.
And then is it seconds or moments after that you hear or feel the bed move? Sorry, Judge.
Okay, so I need to turn it on.
Yes, Judge. What time passed between the time you heard the close and the time you feel the bed move or something signaled to you that there was someone getting in the bed?
Like seconds.
And your reaction to that was to scoot toward the window, is that correct?
Yes.
You were facing toward the window, correct?
Yes.
You were not facing toward the side of the bed where this person was, were you?
No.
You weren't looking at this person.
No.
Now, at that moment, who do you believe was in the house? Besides the person in the bed, who else was in the house, do you believe?
My grandma and my auntie.
Okay. Do you ever remember telling someone that there was a person who I believe her name is Dijanay in the house?
No.
Do you know a person by that name? I may be mispronouncing it, I
Yes,
apologize.
that's my cousin, but I don't remember her being in the house.
Okay, so you don't remember ever telling anybody that there was a Dijanay in the house?
No.
So, at this moment, there's someone in your bed. You're scooting away. That person is scooting toward you, correct?
Yes.
Your grandmother is directly across the hall, correct?
Yes.
Your aunt is where?
Upstairs.
Upstairs. And Dijanay, we don't know about. So, at that moment, you don't say anything.
No.
You don't get out of bed.
No.
Is there a space between your side of the bed and the wall of the window? You know what I mean by that?
No.
If you were to keep scooting, would you fall out of bed on that side?
No.
What would you run into?
The wall.
Is there a window there?
Yes.
So you did not yell out, is that correct?
Yes.
You didn't say anything to this person?
No.
As far as you know, at that time and later in that time, there was no gun present, was there?
No.
There was no knife present?
No.
And you said this person didn't say anything, correct?
Yes.
So that means this person didn't make a threat.
No.
And again, to that presence, whoever it was, scooting toward you and you scooting away, you said nothing.
Yes.
This person touched you in a number of ways, and one of the things you did was to cover your face, isn't that correct?
Yes.
That means to put your hands, how did you put your hands? Could you demonstrate?
Well, I just put my one hand that way and turned my head.
So
Can you demonstrate that again?
hand up to what is her right eye, turning toward her right, if I've got it right. I can stand to be corrected. So this same person in your bed, who you can't see, was saying nothing, is that correct?
Yes,
And he was touching you.
yes,
And he touched you in various parts of your body?
yes,
And when that happened, you again said nothing?
yes,
And you did not get up and run?
yes,
And you did not turn on the light?
yes,
At some point, you hear your aunt, or who you assume is your aunt, right?
yes.
What did you hear?
Well, she turned the light on and I heard her looking for stuff.
Okay. Well, let's slow down a moment. Before she turned the light on, did you hear her moving in the hallway?
No,
And so the first thing you became aware of is a light clicked on?
yeah,
So there was no warning before the light was clicked on?
no, I don't know.
And at that moment, before, in the seconds before that light was turned on, what was this person doing to you?
Had my mom down.
So does that mean you're laying on your back?
Yes,
Was your head against a pillow or against the bed?
I don't remember.
Well, again, I can only rely on you, but I thought I heard you say you were laying on your bed. Is that right? In the seconds before the light goes on and your aunt comes in.
Can you read that?
Yes, thank you for that. In the seconds before your aunt came in. So you remember your aunt coming in and turning on the light, right?
Yes,
Okay. In the moments just before that, you were laying on your back because you said he was touching your vagina.
yes,
Okay. Was his head between your legs?
yes.
Was your face up? In other words, if you looked up, would you see the ceiling?
No, I wasn't facing, no, my head wasn't faced like this. My head was turned the whole time.
Oh, okay. Thank you. So your head again was turned toward the window in the wall.
Yes,
Was your hand over your face?
yes,
And so you don't know what his posture was at that time. You don't know, was he standing on the floor and doing that? Or was he laying on the bed? Because you couldn't see him.
but I felt him down there.
Yeah, I know you felt him down there, but I was asking, did you know where he was on the bed? Or was he standing? What was he doing? Do you know?
He was laying down in
Okay.
between my legs.
All right. And so at that moment, when that was happening, your aunt turned the light on.
Yes,
And then what happened the second she turned the light on?
then he stopped and he just laid across me.
Okay. And at that point in time, if you know, was there a cover on the bed? Was there a cover over you? Was there a cover over he?
Yes, the cover was over him
How do you know that? If your face was turned away and your hand was to your eyes.
because I had a cover on him.
So do you know if he was on top of or under the cover?
He was under the cover.
Again, how are you able to know that if your face is down toward the window?
Okay.
You don't know? And how did you know it was your auntie who came in the room?
Because I know she had to be at work in the morning, so I was thinking that she was just getting ready for work.
Okay. Is that something you know about your aunt?
Yes,
So when you say your auntie came to the door and turned on the light, is that because you know she usually does that? Or is that because you actually saw it?
no, that she usually does that.
Okay, so that means you didn't actually see her. You just assumed it was her.
Correct.
Now, at that moment, you're assuming it's your aunt, but you didn't say anything to your aunt.
No,
You didn't call out to your aunt.
no.
And I know these are hard questions to answer, but I'd ask for your best estimate. How long did that moment last where you said she turns the light on and she comes into the room? to look for something?
It was just real quick. She got what she went in the bathroom.
Where do you think, if you know, where did she go to get something?
The dresses are right here when you go in the room, so she was right there.
Did you hear like a dress? I'm sorry. Did you hear a dresser drawer move in and move out?
No.
Did you hear some cloth being pulled across some surface?
No.
Did you see her taking something?
No.
So what gave you to believe that she came in and did something in the bedroom?
I saw the light turn on. I heard somebody come in the room, and I'm guessing it was her because she had to be at work in the room.
Okay. You could have called to her, but you did not. Is that correct?
Yes.
Does this person on top of you move the cover to cover himself?
No.
Nothing got moved on the bed as you recall.
To get under the cover?
Yes.
He did move the cover.
You moved the cover to get under the cover?
Yeah.
Okay, and that's while the light is on and your aunt is coming in and coming out of the bedroom?
No, he was already under the cover doing what he was doing. So when my aunt came in, he just laid flat.
Okay, so he moved when your aunt came in. He moved by laying flat.
Yeah.
He went down, so to speak.
Yes.
So at that moment, both of you are flat on the bed?
Yes.
After that, did you hear anything else happening after your aunt left the bedroom?
After she left and went in the bathroom, then he got up and got his stuff and he went down the basement.
Okay. Did you hear anything? Did you hear your aunt doing anything in the bathroom?
Yes, I heard that she turned on the shower.
Did she close the door after she left the bedroom? Your bed, the bedroom you were in? Or couldn't you see?
I don't remember if she did.
Is that because you don't remember or because you weren't in a position to see?
I wasn't in a position to see.
And as far as you know, is the door to the bedroom open or closed?
I said it was open.
And do you have any idea how long you lay there before your aunt comes back?
Like a couple of minutes after he left.
Can you hear anything else in the house besides the shower?
No.
Your aunt comes out and comes into the bedroom and eventually you tell your aunt that Gary has touched you. That's what you say, right?
Yes.
Do you remain in the bedroom for a while?
Yes.
And do you go across to the bathroom eventually?
Yes.
What do you do when you go across to the bathroom?
Want to go use the bathroom?
You don't take a shower at that house, do you?
No.
You hear conversations while you're upstairs. I'm sorry, while you're in that bedroom, you hear conversations downstairs?
Yes.
Now, at some point, does your mother and father come?
Yes.
Do you know if they come at the same time or do they come in different vehicles, if you know?
Yeah, they came in different vehicles.
Who takes you home?
My mom.
At some point, you have a conversation with your father, correct?
Yes, when we get home.
Oh, thank you very much. I was about to ask you. It occurs at home?
Yes.
At home, you take a shower, correct?
Yes, that's after I got from the hospital.
Are you sure you didn't take a shower while you were at home before you go to the hospital?
No.
Now, as part of the investigation of this case, do you recall talking to a police officer named Grace Wilhelm? Do you remember talking to a female police officer?
Yes.
Okay. Do you remember her asking you, for the end of the conversation, did you see who committed the sexual assault? Do you remember that question?
Yes.
Do you remember you said no?
Yes.
Do you remember the question, how did you know it was Darius?
Yes.
Do you remember this answer? Because he was the only boy in the house.
Yes.
Do you remember these questions? Did you see his clothes?
Yes, I remember.
And your answer was no, correct?
Yes.
Did you see his hat? Your answer was?
I don't remember that question.
And then you were asked about that, and do you remember your answer? I didn't see him because I was facing away.
Yes.
How many times did your aunt come to the door or into the room?
One.
One time?
She came twice to get her stuff, and then another time when I told her, when she came back into it.
If you could tell me this, when someone comes from where your aunt was sleeping that night and goes to the bathroom, does she have to pass the bedroom that you were in?
Yes.
And the bedroom that you were in, the door was open?
Yes.
I just have one set of more questions to ask you. Do you recall going to what was called a parole violation hearing?
Yes.
I think it was here in Detroit, right?
Yes.
And at that, you described what happened.
Yes.
Do you remember at one point you were given the question, I believe it was by Darius Watkins, did I beat on the window? And do you remember this answer? No, he banged on the window trying to scare me.
Yes.
Can you explain that? What window banging was there that night?
It was on not the window that I was next to, but the window that was like over there by the closet.
In the same room?
Yes.
Okay. And when did that happen?
This was before I let him in the house.
This is before you let Darius in the house?
Yes.
So that was sometime between the time you got there and the time you went to bed?
Yes.
And do you know who was beating at the window?
No.
Why did you say he was trying to scare me? And I'm referring to the banging on the window.
Because I just figured it was him because then when my grandma told me to go open the door for him, I just thought, okay, then that was him.
So what was the time difference between banging on the window and you're letting somebody in the door? Was it happened at the same time? Or was there?
It was like a little couple minutes after that, and then she told me to. open the door for him.
Excuse me for a moment. Thank you for the patience. You said that this person responded in some way to your aunt coming to the door. What did this person do when the aunt came to the door the first time?
The first time, he laid across.
You laid across.
Yeah.
Did he do anything with the blanket?
No. It was already, he was already down there. The cover was already over him, so he just laid.
And at that point, where was his head? If you know. Well, he wasn't side by side.
No, so it was probably like on our way.
Okay, and his legs were stretched out behind him?
Yeah.
Do you know if they were hanging over the bed?
No, I don't.
Do you know if he was curled up?
No.
You don't know? You can say you don't know?
No, I don't know.
Did you at one point say that when your aunt looked in the room, it looked like only you were in the bed?
Yes.
Even though there were two of you?
Yes.
And even though he had moved when your aunt came to the door?
I'm pretty, yeah, but she didn't see him move.
Well, you don't know that, right?
Correct.
All right. Do you remember ever telling anyone that you took a shower before going to the hospital or the clinic?
No.
Judge, may I have one moment? Sure. Thank you. Thank you. Judge, thank you very much.
Thank you.
Ms. Watkins, counsel asked you a number of questions on where you were looking while this was going on. And was there at any point where you actually looked at the face of the person who was in your room? You mentioned earlier that, you mentioned a mustache. What do you remember about a mustache?
No, because I felt a mustache when he was down there.
And did your brother Darius have a mustache at the time?
Yes.
You indicate that you didn't look at the person, but you felt the mustache. What makes you think it was your brother Darius?
He was the only guy in the house. I didn't think nobody else. There was no no other man in the house.
So there was no conversation, so you didn't recognize the voice.
No.
How soon after you let Darius in the house did you go to bed?
Like, after that, I just lay down.
Did you sit and have any conversation with him prior to that?
So when I let him in, he said something about my clothes.
What do you recall?
They said, why they tight?
Did anyone come in the house with him?
No.
Judge, I have no further questions. All right, thank you. Approach, please. more questions of Ms. Watkins? Ms. Dillon? No, Judge. All right, thank you, Ms. Watkins. You are free to step into the hall. All right, gentlemen, just a second. We're finishing up an exam. We're on closing argument. You can, any other witnesses on behalf of the people?
No, Your Honor, the people have certified medical records, which I guess we would admit to the court, that show injury, based on our conversation in the hall. I understand that this is gonna go today, so I don't know if the court actually wants. Counsel has a copy, so.
So we'll have, do you have any objection to them being admitted, Mr. O'Donnell?
No, I don't. I would have had comments about their content, but at this point I do not.
All right, so People's one medical record for Ms. Jessica Watkins will be admitted. Anything additional, Mr. Dillon?
No, Judge.
Mr. Argument? Mr. O'Donnell?
Judge, yes, Judge, I'm going to ask the court to dismiss the charges based on the fact that the complaining witness could not, did not, and seems to be unable to identify the perpetrator. All her identifications, such as they are based on assumptions about who might have been home that night, who was home earlier that night. But during the actual event, other than saying the person has a mustache, and I think everyone is aware that a mustache is a common feature of African-American males. Other than that, there's no identification. And based on that, Your Honor, I move to dismiss.
All right, thank you. So the court received People's one, which is the medical records of Ms. Jessica Watkins. The court also heard from Ms. Watkins, who's 17 years old. She knows Darius Watkins as he is her brother. She identified him in court today. She said on February 21st of 2020, she went to her grandmother's house to spend the night. Her grandmother lives in the city of Detroit. She said that at her grandmother's house was her grandmother, her aunt Alicia, and her brother eventually came to the house. She said that she went to spend the night and she was planning to leave in the morning. She slept in her grandmother's bed. The TV was off. And she said her grandmother slept in another room. She testified that she believed Darius entered the room. However, she was unable to identify him. She says that she never looked at the individual that came into the room. She never spoke to the individual that came into the room. The only way she knows that it was a male individual is because at some point while that person was in the room with her, she put her hand on his penis and was moving that person's penis, and that person had a mustache that she felt when he performed oral sex on her. She says that she never communicated with that person. She never looked at the person. They lay in the room for an amount of time that she was unable to identify. She says that she believes no one else, no other male was in the house, but she does not know. She does not know who was in the room with her. And based on the information that the court, the evidence that the court was presented, the court does not know who was in the room with her. So the court is going to dismiss this case. I don't believe that there has been sufficient evidence to identify whomever was in the room with her doing these things to her on the day in question. I believe that the prosecution is still seeking additional evidence which may confirm who in fact was there. But based on what I've heard, the court is not satisfied that probable cause has been met in this case will be dismissed without prejudice.
Thank you, Judge.
And thank you, Judge. Thank you. Mr. Coolidge, are you ready?
Ready, Your Honor.
Who's your client again, Mr. Cludier?
Judge, his name is Dion Henry.
Is the prosecutor out in the hallway? Ms. Johnson, is this your case?
No, this one's Mr. Cars.
Okay. He's not in there?
He's on the way.
Oh, thank you. Just a second, we're waiting on the prosecutor.
Okay.
This is the people of the state of Michigan versus Dion Henry, case number 20-61706. Mr. Henry is charged in counts. One was malicious destruction of personal property, 1,000 or more, but less than 20,000. Your appearances, please.
Morning, Stephen Howard, please.
Good morning.
And, or good afternoon, Your Honor. Jamil Kuja appearing on behalf of Mr. Henry. Your Honor, I'd ask to waive his presence today.
All right, thank you. The court will waive Mr. Henry's presence for today's probable cause conference. Mr. Kuja, is this the first PCC in this matter?
It is, Judge, and I have discovery, and I've discussed the matter with Mr. Henry, and he wishes to set the matter for exam.
All right, I'm going to adjourn it only because I'm trying to get some of the older cases scheduled before the newer cases. So the PCC will be adjourned to February 18th at 8:30 a.m.
Okay, that works. Thank you, Your Honor.
Thank you.
Have a good day. Bye.
You too. Sir in Wayne County, what's your name? Are you able to unmute yourself, sir?
I'm sorry, did you call me, Your Honor?
I'm talking to the gentleman in Wayne County, trying to obtain his name.
That's Mr. Johnson, Antoine Johnson.
Okay, just 1 second. Is the prosecutor here on Antoine Johnson?
Yep, Antoine Johnson.
This is the people of the state of Michigan versus Antoine Johnson, case number 20-F58-212. Mr. Johnson's charged in count 1 with weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carrying concealed. And counts 4 and 5, weapons, felon, firearms. He's placed on notice that he is a habitual offender force. Your appearances, please.
Good afternoon, Stephen Howard,
Thank you.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Johnson. I apologize, Your Honor, about my tardiness. I was led to believe that this matter had been put over because he does have a pending psychological profile that's being developed on his behalf. And I was trying to get him before Judge Talon today, but I was led to believe, not the court's fault, my fault, that the date had been moved to another date, but I'm here and present with Mr. Johnson.
Thank you. Mr. Johnson, state your name for the record.
Antoine Johnson.
Good morning, or afternoon. Today is the date and time set for a hearing. I think it's scheduled for a competency hearing. Is that correct, Mr. Perkins?
That's correct, Your Honor. We had, and I don't know if that found its way to your file, but we had filed a notice of insanity defense. And so we're waiting for the responsibility, criminal responsibility, but we're also seeking an independent, a private independent to counteract with respect to the finding of competency by the forensic center. And that's the confusion that I had about today's date. But I did look at the register of actions, and it was our fault that happened on our end.
All right, thank you. The court is in receipt of a correspondence from the Center of Forensic Psychiatry. It's authored by Lisa Muir. It's dated December 1st, 2020. And in it, she indicates that Mr. Johnson was referred to the Center for Forensic Psychiatry for evaluation of criminal responsibility. They have made requests of the prosecutor's office on 3 occasions to provide them the police report and the complaint, and they have not received a response. Mr. Carr, they need that information so that we can move forward in this case.
Yeah, I'll be sure to send the line again. I do have in front of me a letter from December 22nd stating that the report was being forwarded and giving the date of the competency hearing as today's date. That's from at Stoloff sent that letter, so I think they should have received it, but I can send it again if they have.
Or call and contact someone from the forensic center to make sure that they have it, because we need to at least check my email and see if I received anything. But we need to make sure that they have what they need so that we can move forward. So the court is checking, I'm checking my emails to see if the report has been emailed to me. And I don't see it. So, what day do you have? What's his day in front of Judge Talon, Mr. Perkins?
I have just one moment, Your Honor. It is we're back in front of Judge Talon on just one moment. It is the beginning of March, Your Honor. Just one moment.
All right. I'm going to put this matter over to allow the Forensic Center to prepare the report.
March 18th.
Thank you. And so we'll come back on, let's see, we can come back on March 18th.
Yeah, if we could do, because he has us in, I believe we're in the afternoon on March 18th. And so if you're doing the morning, that works out well.
All right, March 18th at 9 a.m.
Thank you, Your Honor.
Thank you.
Be safe.
We'll see you then, Mr. Johnson. Thank you.
All right.
Good morning, Your Honor.
Good morning.
Let
me do Mr. Arm first. Mr. Arm, unmute yourself.
Okay.
Yeah. Mr. Arm?
Yeah, I'm ready.
Who do you have?
Curiosity Polk.
Thank you. This is the people of the state of Michigan versus Kunosi, Kunosi, Polk, Polk, case number 20 F62533. Mr. Polk is charged in count 1 with weapons, firearms possession by felon, count 2 weapons, ammunition possession by felon, count 3 weapons carrying concealed, and counts 4 and 5 weapons, felony firearms. He's placed on notice that he is a habitual offender court. Your appearance is please.
Good afternoon, Stephen Carr, on behalf of the people.
Thank you.
Good afternoon, Judge Daniel Lamb, P6107 for Mr. Polk. Asked to waive his presence for today's hearing.
All right, Mr. Polk is out on bond. Is that correct, Mr. Arm?
That's correct.
The court will waive his presence for today's hearing. This is the date and time set for first probable cause conference, correct?
Yes.
The court is adjourning the PCC to February 18th at 8:30 a.m.
Can we get an exam day, Judge?
No, we're gonna adjourn it because this is the first time it's up.
Okay.
Do you have discovery?
I do not actually.
Okay, so we'll make sure that Mr. Carr provides this discovery to Mr. Arm. And we'll see you back on the 18th at 8:30.
Okay. Thank you, Judge.
Thank you. Alawamli, you have Darnell Black?
Yes, Your Honor. Is he present?
I don't see him by name in the waiting room.
Judge, is he in custody or no?
He's not in custody.
I'm sorry, Judge?
No, he's not in custody.
Judge, I did not receive an appointment. I recall I didn't receive an appointment on him. Is there a phone number on the sheet for my appointment?
We don't have that information.
It's not in the court file?
It's not.
Judge, can we adjourn this PCC? I need discovery, and I'm going to try to locate Mr. Black. So I'm asking for adjourned PCC. Sure.
This is the people of the state of Michigan versus Darnell Black, case number 21, F55195. Mr. Black is charged in count 1 with assault with a dangerous weapon. Count 2, weapons, felony firearm. Count 3 is a misdemeanor. Your appearances, please.
Good morning, Your Honor, or good afternoon, Your Honor. Brittany Johnson on behalf of the people.
Respect to Your Honor, Attorney Alawamle, bar number 66874 on behalf of Mr. Black. Today's initial PCC, we would be requesting an adjournment for discovery and for me to locate Mr. Darnell Black.
All right, thank you. I believe this is the first PCC in this matter. The court is going to adjourn to February 18th at 8:30 a.m., allowing you an opportunity to locate your client. If you don't have him by then the court is going to issue a warrant for his arrest.
Respectfully, Judge, February 18th, right?
February 18th, yes.
Thank you, Judge. You have a wonderful day. Madam Prosecutor, do you have my email for the discovery?
If you want to just throw it in the chat real quick, just so that I make sure that I have it, that'd be great.
Okay, it's my first name, then jd@yahoo.com.
Perfect. Thank you very much.
Thank you. Thanks.
Thank you.
Thank you.
So we're in recess until 2 o'clock.
Okay. Your Honor, just so you know, I am waiting for Mr. Kearney on McLeod, and I don't have an assigned counsel for Larry Garrett.
Okay, we'll contact the defender's office. So we're in recess until 2, so.
I've contacted everybody already.
Hopefully they'll show up. If you have Mr. Kearney's number, call him and tell him to show up at 2.
I called him.
I'll do my best to track him down. Thank you much.
Thank you.